visit for the Honorable United States Court of Appeals for the Fourth Circuit. I admonish you to draw nigh and get their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you very much. Have a seat. We're pleased to have y'all with us today, particularly pleased to be back in Richmond, or at least for the most part. We'll hear the first case, 20-1576. Mr. Rathod, did I pronounce that correctly?
It's Rathod, Your Honor. Good afternoon, Your Honors. My name is Jayesh Rathod. I'm counsel for the petitioner, and I'm also a professor and supervising attorney with a clinical program at American University, Washington College of Law. And I'm absolutely delighted to introduce to you today Maya Sukazaki and Jeremy Pado, who are law students in their third year at American University. They will be presenting the argument for the petitioner today, and both have entered their appearance before this court consistent with local rule 46A.
Well, we certainly appreciate all the work that you do for us, and are excited to hear from the students. Ms. Tazaki, if I got that close, roll with it. We're happy to hear from you.
Thank you, Your Honor. May it please the court, my name is Maya Tsukazaki for the petitioner, Mr. Miguel Angel Ibarra-Chavez. Today, we are asking this court to grant the petition for review for at least one of three reasons. First, the board abused its discretion by ignoring essential, legally significant evidence favorable to the petitioner in his application for relief under the Convention Against Torture. Second, because the board failed to properly apply the aggregation standard from this court's precedent in Rodriguez-Arias. And third, because the board failed to apply a de novo standard of review to petitioner's claim, which is a mixed question of facts and law. Your Honors, if I may first turn to the question of abuse of discretion. This circuit has held that the immigration judge may not ignore unrebutted, legally significant evidence. That is from the case Bahrain v. Holder. And in this case, the immigration judge and subsequently the board in affirming ignored legally significant testimony from expert witnesses. The immigration judge specifically even ignored final conclusions and opinions of the expert witnesses, despite the fact that they provided lengthy statements, and one witness, Dr. Moody, testified, and the immigration judge at the hearing found her to be credible. Still, the immigration judge ignored and failed to discuss these overall findings and individualized conclusions related to Mr. Ibarra's claim from the expert witnesses. If I may give an example of one statement that was ignored, Dr. Moody in the concluding paragraph of her affidavit said, and I quote, "I believe there is a very high risk that Mr. Ibarra-Chavez would be tortured and murdered by gang members if he were forced to return." This is page 514 of the record. And additionally, Dr. Montgomery in her concluding paragraph said, and I quote, "I strongly believe that the applicant's life is in danger should he be returned to El Salvador. Returning the applicant to El Salvador may well mean the same fate as his brother, a death sentence." That is page 561 of the record. Here, the immigration judge clearly ignored evidence from our expert witnesses related to the evidence from multiple sources of torture and turned a blind eye to unrebutted, legally significant evidence on the record. At a minimum, we argue the immigration judge should have been required to address the unrebutted conclusions of the experts on the record. Now, opposing counsel may assert that we are asking the immigration judge to mention every line of the evidence in their opinions, which is not the case. As I mentioned in this case, even the conclusions and overall opinions, the reasons that the expert witnesses were brought as evidence were not addressed by the immigration judge in her analysis. And consistent with this court's case law, at a minimum, this unrebutted, legally significant evidence should have been grappled with in the immigration judge's analysis.
Counsel, does it matter to you that the conclusions that you point to are on the ultimate question to be decided by the immigration judge? Does that make a difference? So it might be one thing to ignore, factual information or subsidiary positions provided by an expert, but when the expert offers the conclusion on the issue to be decided, does that make a difference to your analysis?
Your Honor, that is what we are arguing, that at least these unrebutted conclusions should have been addressed. They were related to the individualized risk of torture, as Your Honor mentioned, and the immigration judge did not address them or did not mention why she did or did not find them credible in her analysis of the petitioner's claim. Instead, she cherry-picked specific pieces of evidence related to extrajudicial killings, and also spent nearly a paragraph on a single footnote while ignoring these unrebutted, legally significant pieces of evidence. Your Honor, we'd also argue that the immigration judge failed to fully consider some reports that were included as evidence from both our counsel and the DHS, specifically State Department human rights reports, and also reports from Congressional Research Service that provided evidence of the risks that Mr. Ibarra would face if returned, risks of detention, and also risks of extrajudicial killings and the impunity that law enforcement experience. And if I may point to a few other cases on this issue, I Chen v. Holder from the circuit held that the board cannot selectively consider evidence. And in Tassi v. Holder, this court also held that the board cannot rely on isolated snippets of evidence, as the immigration judge did in our case, we would argue.
Can I ask a slightly different question? I'll phrase it as a hypothetical so that we don't get into what you think of the characterization. But if hypothetically an immigration judge cast doubt on the various premises of an expert that undermines the ultimate conclusion, would that be sufficient? So in other words, if I call into doubt point A, B, and C, but as calling those three into doubt, I then don't directly address the conclusion that flows from A, B, and C. Is that sufficient? Or in your view, do they have to separately address the conclusion, even if they undermine its foundation?
Your Honors, I believe we would still argue that a conclusion or final opinion, at least of the experts, should still be addressed by the immigration judge.
And why? I thought that would be your answer. Why is that? Why would that be the scenario?
Your Honor, I believe we could point to the case Cordova v. Holder from this circuit that held that the review of the board's review is limited to the actual reasoning that the immigration judge provided, and thus, in order to enable the board to review, the immigration judge should address all unrebutted, legally significant evidence, including these conclusions from the expert witness.
They're not evidence, right? I mean, that's a little bit of the problem, right? So it's like point A, B, and C. If I disprove it's not A, not B, not C, then the conclusion is sort of by definition been rebutted. I mean, this is the hypothetical, right? I'm not asking you to concede that that's what we have here. But if I've undermined each of the foundational elements of the conclusion, why would I have to separately address the conclusion, given that I've undermined each of its foundational elements, or even just one of its foundational elements?
Your Honor, I believe that in an immigration case where there are so many different factors to be considered, so many different potential statistics and other evidence that could be addressed in the final conclusion of these experts, that is why we would argue that the conclusion should still be addressed. I suppose, hypothetically, if the immigration judge did go on at length and rebut every single piece of evidence that was relied on by the expert, then perhaps in that case, the conclusion wouldn't need to be addressed. But that is not what occurred in this case. There were only very specific statistics and notes pulled from the expert statements rather than addressing the entire affidavits. And so we're arguing at a minimum, these unrebutted conclusions should have been addressed. Your Honors, if I may turn to the issue of aggregation, unless there are further questions related to abuse of discretion. So, Your Honors, we argue that in this case, the immigration judge and the board committed at least one fundamental error in applying this court's precedent of Rodriguez-Arias by conflating two distinct sources of torture, namely the law enforcement and the vigilante death squads. So, Your Honors, Rodriguez-Arias is requiring each source of torture to be considered separately before aggregating the total risk of torture to the petitioner from all sources. But in our case, in the same series of paragraphs, when applying facts to her analysis, the immigration judge relied on evidence specifically related to risk of torture from law enforcement before concluding, and I quote, "The likelihood of torture from police and vigilante death squads is significantly below 50%. That is page 70 of the record. And so effectively, the immigration judge and then the board in affirming referred to both these vigilante death squads and law enforcement in a single breath, effectively, without providing distinguished analyses for each.
So what's the best, I mean, it doesn't have to be from our circuit or elsewhere, but you seem to suggest that the use of the phrase separately there suggests that each risk, the IJ must assign a percentage to each risk and then aggregate them as a mathematical matter, as opposed to just consider both of them. What's the best authority you've got that the immigration judge must assign a specific percentage to each risk, as you say, separately?
Your Honor, respectfully, we would not necessarily argue that a specific percentage needs to be assigned to each risk. We do think that our case shows some ambiguity in Rodriguez-Arias. And so as in our brief, we mentioned we'd recommend something that looks like a hybrid of applying quantitative and qualitative terms to this analysis. And if I may, we would like to recommend three particular points of guidance on how aggregation might be conducted under Rodriguez-Arias. If I may articulate these. First, we are recommending that the agency be required to provide at least sufficiently detailed explanations in order to enable meaningful judicial review. Intuitively, the more complicated the evidence is, the more complete the analysis should be, consistent with this court's ruling in Molina Mendoza v. Sessions. Second, we'd recommend requiring the agency to provide specific and cogent reasons for each separate risk assessment before aggregating the total risk. And then third, we would recommend that the agency describe the separate and then the aggregate risk of torture in quantitative terms, if possible, with using the record, or at least by using sufficiently specific qualitative descriptors. So, and these should be related to individualized risk of torture. So, Your Honors, if the record allows and includes quantitative terms, the immigration judge might.
So, which of those things do you think didn't happen here, or what went wrong based on this record and what was before this immigration judge and the BIA in this case?
Your Honor, we would respectfully argue that all three of these recommendations did fail to occur in our case. There was not a sufficiently detailed explanation of all of the risk from all three potential sources of torture. There also was not there were not specific cogent reasons given for risk.
I don't want to nitpick, but the IJ broke them out and gave, I've found at least three reasons why the likelihood of torture by gangs was below 50%. Three separate, reasons and explanations. And then similarly, three different explanations and reasons for why government officials or vigilantes, the evidence didn't support finding that the likelihood of torture by those was more than 50%. And then went on to say, and adding them all together, it's still less than 50%. So how much more is required?
Your Honor, we would argue first that the conflation of the vigilante death squads and the law enforcement was an error, and there was not a separate analysis of the risk from vigilante death squads. There were not specific and cogent reasons given for any analysis because there was no analysis from the immigration.
But if the two of them combined is significantly less than 50%, why would we think that analyzing them separately would result in anything different?
Your Honor, the immigration judge relied on evidence related to law enforcement without providing an analysis of the vigilante death squad. So we would argue that this case should be remanded for the immigration judge to consider and provide an analysis of evidence related to these vigilante death squads because they are a distinct potential source of torture that Mr. Ibarra would face if returned. And then additionally, we would also argue that these kind of qualitative descriptors given by the immigration judge were not specific enough by saying that the risk of torture is quote unquote significantly below 50%. for the separate sources, but then also in the aggregate. Intuitively, it does not necessarily make sense for the total risk separately, and then the total risk in the aggregate to use the same qualitative descriptor. And so we would argue for recommend that there be more sufficiently, a requirement of more sufficiently specific qualitative descriptors to be used by immigration judges. Your Honors, I see my time is running low. If I may quickly turn to the issue of the mixed question of fact and law. In this case, the board failed to apply bifurcated review to this mixed question of fact and law. This court has held in Turks and Beholder, and the board has also held in matter of RAF that torture the definition of torture is a legal question. So torture has a definition in the regulations, and determining whether certain facts rise to that definition of torture is a legal question. So for example, whether someone would be subject to imprisonment or a beating in the future, that is a factual question, but whether that conduct rises to the level of torture is a legal determination. That makes this a mixed question of fact and law that in our case was not properly applied, and the legal question was not reviewed de novo by the board. Your Honor.
Counsel, before you sit down, I'd like to ask Judge Traxler if he has any questions for you in particular.
No, thank you. No questions, Judge Richardson. Thank you.
Okay, Your Honors, I see my time has ended. May I briefly conclude?
You may.
Thank you, Your Honor. We urge this court to grant the petition for review and remand so that the immigration judge can correctly consider all legally significant evidence and properly aggregate the risk of torture to our client from all three possible sources. Thank you, Your Honors.
Thank you, counsel. Ms. Boggy, if I'm getting that close.
The guy. Good afternoon, Your Honor.
The guy. Thank you, counsel.
Thank you.
We're happy to hear from you.
Good afternoon. May it please the court. I'm Sharzad Begay, representing Respondent, United States Attorney General. This is a case in which the petitioner has failed to establish a particularized risk of torture, and the record evidence in this case does not compel a reversal of the agency's finding. We therefore request that the petition be denied. In assessing the likelihood of torture in this case, the agency considered all sources of potential harm to the petitioner, both separately and in the aggregate, including harm from gangs, police, and vigilante groups. And in doing so, the agency considered all relevant evidence. The agency directly addressed petitioner's claim that he would be targeted because of his past experiences in El Salvador, as well as his tattoos and police cooperation here in the United States. And I would like to go through the agency's analysis. First, with respect to gangs, the agency found it significant that the petitioner has not received direct or indirect threats since 2011 from gangs. Additionally, after his brother's 2011 death, he was able to continue living in El Salvador for about a year and a half, and he was not significantly harmed during this time. The absence of any threats since 2011 or any indication of interest in him undermines his claim that he would be at risk of torture in El Salvador because of having witnessed his brother's death or refusing to join a gang. In addition, with respect to his claim that he would be targeted because of his police cooperation in the United States, there's no indication that the gang in El Salvador is aware of his cooperation or would become aware. This claim is based on speculation. Additionally, there is record evidence showing that he has affiliated with MS-13 here in the United States following his 2014 police cooperation. And if that is in fact the case, there's no indication he has been threatened by the gang here. His own witness, Dr. Montgomery, stated that if the gang in the United States was aware of his cooperation, that would have been communicated to the gang in El Salvador and he would have been threatened at this stage. With respect to the police and vigilante death squads, the immigration judge in this case recognized that suspected gang members and gang members are at a higher risk of torture. However, despite this generalized evidence in the record, there's no other indication, there's no evidence that he would be at a particularized risk of torture, whether by police or vigilante squads. He would have to present more than the country conditions evidence, which both the IJ and the board noted in their decisions.
Counsel, can you respond to your colleague's suggestion that it is error to have grouped those two together, police and vigilante groups, that for some reason that those need to be discussed in a separate paragraph or in a separate way? Why do you think that's not right?
Okay. Well, for two reasons. First of all, in this record, the fact that the immigration judge did consider all sources of harm in the aggregate and concluded together, whether separate or together, they would not rise to the level of clear probability. It would not have made a significant difference. It was analyzed completely separately. And also, there's no indication in the record that these are completely separate entities, as we noted in our brief. The immigration judge, Dr. Moody stated in her affidavit that there was some overlap. There's indication that the police are involved in the vigilante squads. And additionally, this is consistent with State Department reports. And petitioner has not shown these are separate entities. But ultimately, the fact that the immigration judge took a cumulative approach resolves this issue in concluding that they did not establish a clear probability when considered together.
So I understand that it seems like you're saying 2 points. One, you can consider groups together as long as you're explaining what you're doing, but separately here, although maybe not necessary, the fact that those two groups were related to some degree sort of further justified doing so. Correct,
Your Honor. Yes. And I would also like to address petitioner's claim that he would be identified as a possible suspected gang member upon removal. He claims that his criminal history will be disclosed upon removal and that he would be targeted under Decree 717. He would be detained and tortured. And to that extent, there's no indication that he would be flagged by the Department of Homeland Security as a suspected gang member. As we noted in our brief, the Department of Homeland Security would indicate gang affiliation if that's the reason someone is being removed. And while there is some evidence of gang affiliation here, his criminal conviction documents don't identify him as a suspected gang member. Even assuming that were the case, even if he is identified as so or suspected as being a gang member, he would still have to show a clear probability that he would be detained under Decree 717 and then tortured. So this is a chain of events that he would have to prove, and he has not done so here. And finally, with respect to his claim that he would be targeted because of his tattoos which he obtained in the United States, the agency noted that as an initial matter, these are not gang-related tattoos. And while he claims that they would be viewed as such, he would still have to show more than a general assertion that he would be tortured just because of that. His evidence rather shows that he could be discriminated against or harassed. There's nothing other than that would show that he specifically would be targeted for torture because of his tattoos. And just to address the claim that evidence was not considered here, as an initial matter, we would argue that the presumption has not been rebutted here, that all evidence was considered by the agency. And as we noted in our brief, a reading of the agency decisions indicates that the immigration judge and the board took into account all relevant evidence. The immigration judge stated that she had evaluated everything. She cited several paragraphs of the expert testimony. She also outlined arguments in support of petitioner's claim. The board as well cited to exhibits provided by both the DHS and petitioner in this case. Ultimately, the immigration judge was not persuaded that the evidence established a clear probability of a particularized risk of torture in this case. And we would argue that there's no indication that there's any legally significant evidence that was overlooked in the agency's analysis of petitioner's claim. And with respect to the aggregation argument here, we maintain that the agency's decision is consistent with this court's holding in Rodriguez-Arias. The immigration judge's opinion reflects that she identified every single source of torture, considered it separately in the aggregate, as I mentioned, and ultimately concluded that they did not rise to the level of clear probability. And I would finally like to address the argument that petitioner raises with respect to the board's review. As we noted in our brief, the petitioner did not exhaust the specific claim that the aggregation analysis requires another level of review. As this court has held in Turkson, the factual predictions with respect to CAT, with respect to clear probability, require a clear error review, and this is exactly what the board did here. And just in conclusion, the agency decisions reflect a consideration of all aspects of its claim, and we would request that the petition in this case be denied.
Judge Traxler, do you have anything?
No, thank you, Judge Richardson.
Thank you, counsel. I appreciate your argument. We'll hear the reply from Mr. Padau. Am I close?
Haddo, yeah.
Haddo. I'm 0 for 3 today. I apologize.
Good afternoon, Your Honors, and may it please the court. My name is Jeremy Paddo for the petitioner Miguel Ibarra-Chavez. In the interest of time, I'd like to address a few of the government's positions, starting with the issue of abuse of discretion. We believe that there was an abuse of discretion in Mr. Ibarra's case because, according to the case of Tassie v. Holder, it is an abuse of discretion when a court distorts or disregards aspects of an applicant's claim. And in this case, given the vast disparity between the expert report's individualized conclusions about Mr. Ibarra's risk of torture and the immigration judge's final analysis, those two things, the vast disparity between those two results shows that there is a distortion in the evidence in Mr. Ibarra's claim. And as to the evidence of the lack of threats that Mr. Ibarra received.
I want to make sure I understand that argument. So anytime there's a significant disagreement between the IJ and the experts, then there is a distortion. I mean, that seems like a circular argument, right?
Your Honor, respectfully, in this case, given the expert's language that Mr. Ibarra is at grave danger of being tortured on page 533 of the record, or at a very high risk of torture on page 346, it's not clear that the IJ fully engaged with the individualized conclusions in the record and only focused on one footnote in one expert's report and in isolated facts in another expert report. So when such a distortion exists like this, that varies so far from what the individualized conclusions were, it appears that there was a distortion. But I actually wanted to move on to the issue of the lack of threats that Mr. Ibarra received. And when Mr. Ibarra was threatened several times in El Salvador, which caused him to go into hiding. And given this court's precedent in Ortiz Cruz versus Barr, time spent in hiding does not negate the potential of future harm. And the government also raises the issue that it's not clear that news of Mr. Ibarra's cooperation with police has traveled to the gangs in El Salvador. Well, our expert, Dr. Moody, on page 505 of the record, also provides evidence that when a new deportee or a newcomer enters a community in El Salvador, members of gangs investigate that person, and gangs function as the effective government in many of these areas, including the region of Soyapango, the region where Mr. Ibarra comes from. So it seems likely that his ties to police will be investigated and discovered. And I wanted to address also the issue.
Can I ask that question? So just taking that premise, right? So you say it seems likely that they would learn that he cooperated. And this is the sort of probabilities question, I think. I want to make sure I understand your position. If that was the theory, let's imagine that's the only theory, and I know that's not your argument. Wouldn't we have to aggregate that risk with the whatever the risk is or the probability that if they learned he cooperated, that he would be tortured as a result of it, so that it requires both of those things to be true in sort of basic probability math?
Your Honor, respectfully, I believe that the factor that gangs may the probability of the gangs in El Salvador learning of his cooperation with police might not have to be its own variable in an aggregation analysis, but it could just simply make the likelihood of being tortured by the gangs more true, or make that percentage higher.
But if we'd imagine that there's a 50% chance that their investigation turns up his cooperation, and there's a 50% chance that if they learn he cooperates that they torture him, we wouldn't obviously say there's a 50% chance of his torture, right? We would instead say that, you know, there's a, I believe, 25% chance of his torture, if my math is right.
Right, Your Honor, but it still it would have to be combined with of course with the other sources of torture too. These things like the probability of the gangs learning about his cooperation with police, and also the potential for police acquiescence in apprehension of gangs, or stopping harm from vigilante death squads or others, would also inform other variables in the aggregation analysis. And
thank you, Counsel. Judge Traxler, you got anything you want to add?
Could I ask a question of Mr. Padow unrelated to this case?
Of course.
Mr. Padow, does your family used to run a restaurant here, in Richmond, Delicatessen?
No, but I know what you're referring to. There is a deli with my name. Yeah, they're unrelated. Yeah.
Okay. Thank you. Sorry, Judge Richardson.
No, I actually wondered that myself, but I did not have the guts to ask. So, well, obviously, we very much appreciate your participation. In particular, obviously, American University and your immigration clinic, y'all provide an invaluable service to our court, and we can't thank you enough, both professor and students, for the time, effort, and energy you put into preparing and presenting this case. We'll turn to the next case. I believe our counsel are in the chamber, and we'll ask them to come forward. In 20-1636, Robinson v. Williams, and when they're in place, we'll hear from them.
Judge Richardson, while the lawyers are swapping place,
Mr. Gresham, whenever you're ready, we're not trying to rush you, obviously, but whenever you're ready, we're happy to hear from you.
Thank you, Your Honor. May it please the court, I'm John Gresham, the attorney for the plaintiff. I will note that Ms. Chambers, who wrote the brief, if you had looked, she has gone to the Justice Department. So she is not able to be with the court today.
We're happy to have you in her place.
Age has now come to the court. One issue here, did the district court judge properly apply the standard that this court has set out with regard to a motion for summary judgment? I will say that the case I think best describes this court's position is the Jacobs case at 780 Fed Third 562. And in this case, the court made a determination, if one looks at the last page of the decision, where she says that the only reasonable inference is that the plaintiff proceeded with surgery faced with an incomplete understanding of Duncan's interpretation of the, what they call the inoperative T, which was the second T that took place, but goes on in the same sentence to say that plaintiff misread the intraoperative T. And that is the crux of this case, Your Honor. While, Your Honors, while there was other questions, how did Dr. Williams come to what we think is the falsehood in this case? Certainly the inferences that you can draw, which would require reversal of the district court's opinion.
I had a question about that.
Yes.
Is it defamatory that to say that Dr. Robinson did not have a complete understanding, proceeded with an incomplete understanding of the intraoperative TEE? Is it defamatory to say that by itself, or is it false and defamatory, or is it only when it's combined with the statements by Dr. Williams that she had an obligation? My understanding is the evidence indicates there's a dispute between the parties about whether Dr. Robinson had an obligation to confirm there's a severe aortic deficiency before proceeding to surgery. And so the dispute's not whether she confirmed it or not. She didn't confirm it was severe, and the parties dispute about whose fault that is. But I thought the crux is not really whether she confirmed it, but whether she had an obligation to confirm it or not.
No, that is the Dr. Williams' position. Our position is the second part of that statement, misunderstood. Where does that come from? That comes from the day of the surgery all the way through for the next 3 years. Dr. Williams was saying the following. Dr. Duncan, the anesthesiologist, and Dr. Robinson misread the T to say that it was severe. I will give you the cites for that.
No, I believe you. There's cites about him saying they misread the severe, and she says, well, maybe we didn't even read it at all. Duncan says there's kind of conflicting evidence about that, but I don't think I'm disagreeing with you. I think I kind of saw the evidence as suggesting that it's defamatory to say someone committed malpractice, and the question's not, did she do X, Y, or Z? It's like, yeah, even if she did, it's not malpractice if she didn't have an obligation to do something different.
Correct.
And so that's why I'm saying the crux is kind of the malpractice question. I'm not accusing you of bringing a malpractice case, but I wondered if it's the inferences to be drawn from his implication that she did something wrong, and then he outright said in his reports at times that she did something wrong.
Right. And to some degree, part of the problem is the statements that Dr. Williams continues to make from the date of the surgery through ultimately when he's in front of the North Carolina Medical Board is they read it and it was false. That didn't occur. They did not read it and first determine that it was severe. That never occurred. He has drawn that, for lack of a better term, from thin air, and he continues to say that Dr. Robinson did that. Now, interestingly enough,
I'm sorry, I just want to make sure I understand the argument. So I understand Judge Rushing is referring to this inference, which so to have malpractice, you got to have a duty. And so there's an inference of obligation.
Right.
But I understand that's one of your two theories, but your first theory is that, you know, Robinson misread the T, is necessarily false because she didn't read it at all. And we interpret misread in sort of a medical sense. And so if you misread a T, that's a critique. It might not be malpractice, but that's a critique of your professional competence when in fact she never read it at all. Is that, and I understand that there's a sort of two different theories?
there are, and they become somewhat mixed in the district court's opinion.
But your position is that you could prevail on your claim on either ground, that if I claim, so if I call my law clerk in and I say you misread that precedent, right? That's a critique of his legal abilities. If I say you misread a T, that's a critique of her abilities. If in fact he wasn't the clerk that was working on that case,
right?
And I did it publicly and all these other things, that might be defamatory, even if he had no obligation to read that case or do anything about it. That's one theory. But the second theory is that it's actually fully malpractice because she had the obligation to do it and she didn't do it. But those are separate.
That's correct. And they have gotten somewhat intertwined in this case in a way that I like Judge Rushing's comment, because there's evidence from Dr. Robinson and additional evidence in the record that she did not, the expert, Dr., and I'm going to mangle his name, also said she did not have the obligation. Now, she did learn of the T information very quickly, the sort of factual background.
Before you go to the factual background, just in thinking about these two things, I had a question about how do I understand, what is the standard on which I evaluate the word misread, right? Because we might think of it in a variety of different ways.
You do it because of what Dr. Mitchell did, Dr. Williams did. He went out of the surgery and said, the two of them read the T as severe, and look what it caused. She had this stenography. He goes to her family and says, these two people misread the T as severe, and that's why you have the scar.
I understand that, but I guess I'm trying to ask is I might think about misread in two ways, right? One way is like as an exercise of medical judgment, right? So that I might read a case in an exercise of my legal judgment, or a doctor might read an X-ray or a T, which I understand is somewhat related. And I might, in doing the very use of the word misread, implies that I am applying my medical judgment in this context. But I might also think about it in a more colloquial sense, right? That I like misread what was in the newspaper, which is not professional judgment. Why should I read the former and not the latter?
Because of the circumstance. He says they said it was severe, and that caused the patient harm. They exercised their medical judgment to say it was severe when it wasn't. I came in and saw it wasn't, but it was too late. So it is a medical judgment.
And is the standard on that, and then I'll let you go back to, I know you wanted to talk more about the factual background, but is it your position that we only need conclude that that is at least one reasonable way to understand that language?
Yes.
That's the summary judgment point. And then the jury can decide that question ultimately.
That is correct. That is an inference that is clearly in the record from which a jury could determine that that was false in a way that satisfies the defamation standard. And the fact that it carries all the way through from that day, it carries through to what he tells the people who deal with issues when there is a lawyer saying you did something wrong.
Mr. Gresham.
Yes, sir.
I'm sorry to interrupt you. Before we leave this district court opinion, I wanted to ask you one question. And what I'm going to ask you about is on page 1693. It's the same page where the district judge draws a conclusion. But she says in her order, although moderate AI was a result of the intraoperative TEE and known to Duncan at the outset, is that a fact viewed in the light most favorable to the non-moving party, which of course is your client?
I believe so, Your Honor, because this is a strange case.
You adopt that finding and agree with it?
No. Would you read
So
that
it's
again,
not
Your
being
Honor?
moved.
I may have misunderstood your question, so would you repeat it?
My question is that fact that she recites a fact that is in your client's favor, that it should be viewed in light of the position that you advocate? Do you agree with it or not agree with it?
No, I don't agree with it.
Okay, that answers my question.
Yes, no, I'm sorry, I misunderstood your question, Your Honor.
I must not have asked it clearly enough.
No. I'm an old lawyer with a new case, so I may have misheard you.
So what?
I'm an old lawyer. I'm an old lawyer with a new hearing aid.
So what? Just so that I understand your position. Why can we assume from the record that it was not known to Dr. Duncan? What's the evidence that suggests that she did not know?
You mean Dr. Robinson?
I believe Judge Traxler was asking about whether it was known to Dr. Duncan.
It was Dr. Duncan did the initial T, but then left the operating room. They had Dr. Duncan doing 3 anesthesiology at the same time. The evidence is that Dr. Robinson did not hear what he said when he left, and that the protocol there was typically the anesthesiologist would go to the primary surgeon to tell him what he had learned. He was gone. They have what's called a 2-minute timeout that Dr. Gawande from Harvard has put forward, and there was no mention in the 2-minute timeout that there was any question about the severity. Also, there is no indication that the defendant knew that there was a separate problem, and that was they were going to have to enlarge the portion where they go into the heart. And he acknowledges he did not know that. Now, very quickly, why was he unaware of this? There is evidence in the record he had never read the initial T. He says that. He says that immediately after the surgery, he takes Dr. Robinson in and says, "It's my fault. I didn't see the initial T." And she, for reasons unknown, taped that short conversation. And it's in the record. So why is he making up this story that the two of them misread the T. He had never read the initial T. That seems startling given this case, but very quickly notice that the false statement that these two people misread the T as severe and he corrected the matter, he carries through, and that goes to the carrier. And in that, interestingly enough, Ms. Cook for East Carolina tells them that we probably don't want to include Dr. Duncan in this. There are two transmitted to Mal Mutual. I think it is page 1543 of the record. And as a result, she's the one on the hook. When it goes to the medical board, he still is telling the falsehood. Now, how, since the opinion says this, how does that not impact her as a physician and a cardiologist that I have been, it has been told since the day of the surgery that I misread the T. And this misread is not in the sense of, as Your Honor has said, it's inconsequential. It was very consequential. And Dr. Williams calls in another surgeon to look at this, in part because he now knows the analyst has a problem which he had never known before. He is covering his back end as much as he can by throwing it on Dr. Robinson. Now, to get back though to what really happened, would that have been and by the way, that doesn't come out in what goes to the insurance carrier. What comes out is she and Duncan misread the T, but Duncan is still here. And by the way, she didn't know any of this was happening for over a year. East Carolina didn't bring her in to hear what actually happened. Very quickly, what actually happened was she did not get the information about the T until after the stenography, and she immediately went and got the defendant, got Dr. Williams. And I see my initial time is up. I think I saved 2 minutes, so I'll be back.
Thank you, counsel. Ms. McHenry, we're happy to hear from you whenever you're ready.
Thank you. May it please the court. Laura McHenry from the North Carolina Department of Justice on behalf of Dr. Mark Williams. This court should affirm the district court's decision to grant summary judgment in Dr. Williams' favor for 3 reasons. First, the statement made by Dr. Williams about Dr. Robinson was neither false nor misleading, and therefore cannot be the foundation for a defamation claim. Second,
Can you start with, I don't want you to get away from the two, but what is the evidence that she medically read the T? That she ever medically read the second T before cutting the patient open?
Your Honor, it's a very good question. I think we all are very curious about it, but it's not material to the inquiry before this court.
All right, but I just want to make sure I understand. There is no record that suggests that she read the T before she cut the patient open.
Correct. There is no evidence that she read or sought a clear understanding of the results of the TEE before making that first incision.
Okay, all right. You can go to second and third. I just want to make sure I understood that point first.
Sure. Second, there is no genuine issue of material fact. Where there is no dispute as to the material facts, the district court properly performs its gatekeeping function in declining to send the matter to the jury. And
Well,
third,
can I interrupt just a sec?
of course,
If you agree that she never read them, then the statement's false. Isn't that right?
no, Your Honor, and this is an important point that I want to bring to the court's attention.
How can you misread something that you never read?
Dr. Williams did not say that Dr. Robinson misread the TEE. I want to point the court to the actual alleged defamatory statement in the record. It's repeated several times between pages 362 and 367. What Dr. Williams said was that Dr. Robinson failed to recognize the findings on the TEE that showed only moderate aortic insufficiency.
So you're saying she can't prove he made the statement she alleges in her complaint?
I can direct the court to where Dr. Robinson gleans that word misread. It comes.
No, did you understand my question?
Perhaps not. Please repeat it.
You're saying she can't prove that Dr. Williams made the statement that she alleges that he made in her complaint?
Correct. Dr. Robinson cannot prove that Dr. Williams said she misread the TEE.
Is this in your brief?
Your Honor, in preparation for this argument and combing every single page of the record, this was something I really was trying to dial in on because it was unclear to me what exactly was the statement. So my brief, Your Honor, responds to the appellant's opening brief and this discussion about whether she misread the TEE or whether she didn't read it at all. And of course, my argument, which still stands today, is that that distinction is not useful for the court's inquiry today.
I'm looking at the deposition of Mrs. Cook. This is at 1346 of the joint appendix. And she says that Dr. Williams told her that Dr. Robinson and Dr. Duncan, that they had misread, I can't pronounce the word, the TEE, and that they had misread it as severe when the patient had only moderate insufficiency. She says yes. So why is that not evidence that he told someone that they misread it?
That language is Judy Cook's summary of what happened.
But it's evidence that he said it because that's what she says he said.
I can concede that point.
It's not a transcript, right? She didn't tape it like Dr. Robinson did.
Right.
But it's evidence.
Sure.
It may not be just, the best evidence, but it's evidence that he said misread.
Yes, Your Honor, I can concede that in her deposition, she uses that phraseology. She says he told her that Dr. Robinson misread the TEE.
Okay.
However, what's critical, I think, to this court's inquiry is about whether the statement he made was actually false. And I want to.
Well, but you started this conversation by saying she didn't read it at all. And if you don't read it at all, by definition, you can't have misread it. Right? I mean, that's not like a complicated story, right? I'm not, or please tell me the complicated way that like seeming truism is false.
So I think where we need to look, Your Honor, for clarity on that question is this court's opinion in AIDS counseling, testing services, and Group W television. Because in that case, this court explained that precision and exactitude are not the standard when determining whether a statement is true or false in a defamation claim. This court said that if the gist or the sting of a statement is substantially true, minor inaccuracies will not give rise to a defamation claim.
Right. So if I say, counsel, you severely misread that precedent, right? I'm like, there's not ambiguity about that, right? Like you just read it to me. I'm saying that you misread it. It's not actually true here. This is also be defamatory, right? Because I would say you misread that, right? And it might well be that you misread it. I think you didn't here, but right? But you read it, and so you could have misread it. But if instead I said, you misread a different case that you've never seen before, right? We know that's false. We don't have to evaluate whether you did or didn't because you didn't read it at all.
First, I'll just contest your characterization that that would be defamatory. I don't think that would be injurious to my career professionally, but still, I understand.
No, if I publish out to the bar and I say counsel came in and presented argument to this court as an officer of the court, and she misread the precedent, right? In doing so, and that was important to the exercise of her professional judgment. And so as a result, her client lost, right? Or had his chest cut open, if we want to do the analogy. I think the bar might be interested in that. And I suspect your future employers would be interested that you misrepresented or you misread a precedent to the court, to the injury of your client. I don't think I'll tell you, I would not want that accusation leveled at me. If I write an opinion and Judge Rushing responds by saying, the judge misreads the precedent, I take offense at that because, if I'm doing that, then either it means that I'm not very good at my job or that I'm dishonest, neither of which seem like very good things to be said.
And here, Dr. Robinson asserts that she didn't misread the TE because she didn't read it at all. And so Dr. Williams' response, our argument in response to that is that whether she misread it or misunderstood it or made no attempt at all to read it, the gist or the sting of the statement that she failed to recognize the findings of the TEE, showing that that the aortic insufficiency was only moderate, is true.
Well, that's when you get to the second theory that we discussed with your colleague, which is that the sting is not just that she didn't do it, but that she had an obligation to do it, that she didn't do something that she was supposed to do. She didn't live up to the medical standard. And in reading what Dr. Williams wrote, that seems to be what he is saying. He says she was required to confirm it was severe and she didn't. So why are those statements not false and defamatory, or at least read in the light most favorable to her? She has an expert saying she didn't have to do that. That's not the medical standard. Why is that theory not viable?
Because Dr. Robinson is the only surgeon in the room holding a knife. She has conceded, she has admitted that the results of the TEE can be a contraindication to surgery, to proceeding with the planned operation. There are a number of sites in the record about the timeout. As we know, there's the purpose
but she and an expert say, yeah, it can indicate that it can show contraindications. Like here it showed not only that it was moderate, but that there were other reasons not to even perform the surgery at all, not to schedule it.
Not displayed. Those examples that I just gave are all in the record in pages 103, 112, 507, and 575. She admits that a possible contraindication may be the results of the TEE. She also says that if she had known the TEE showed only moderate and not severe aortic insufficiency, that she would have stopped and called Dr. Williams. Not only that she would have stopped, but that she was required to stop and consult.
But that doesn't answer what I just was talking about. You can say, if I knew that it wasn't severe, I would have called Dr. Williams and said, hey, why are we doing surgery on someone who it's not severe? But it can also be true at the same time that I wasn't required to confirm it was severe before I've conducted surgery because we know someone else has already looked at it and confirmed it, and these things don't change overnight. And she has an expert, is it Kipson, who also says that this is the standard of care. So, I mean, why is there not a classic dispute here about what she was required to do, and why is it not potentially false and defamatory to say she didn't do something that she was required to do?
I don't think the issue is that she wasn't, whether or not she was required to check it, that her contention is that Dr. Duncan was the person who's capable, who's qualified, who's board certified in interpreting the TEEs, and that she says a number of times in her deposition, he didn't tell me, no one spoke up, no one brought it to my attention. So the issue that Dr. Robinson brings to the court is not whether she has the ability or responsibility to read the TEE. The question is that it is her responsibility. I'm sorry, not the question. The fact is, it is her responsibility to confirm that with the cardiac anesthesiologist who's in the room.
What's the record? Right. What's the record that says that that's the only possible conclusion that we can draw? That she has the obligation to confirm? Right. I mean, she's got an expert that says that's not true. She says that's not true. Right. So what is the record evidence that tells us that that's the only possible inference, that she has a duty, a medical duty under the standard of care to confirm? That might not be sufficient for you to win, but that would get you somewhere. What's the record to suggest that?
Your Honor, I think it's Dr. Robinson's own testimony in this case. It's her own.
All right. So where does she say that she has a duty under the medical standard of care to confirm at that point, as opposed to rely on the doctor that said it was severe already based on the first T? Where does she say that? Point us to it.
So first, I want to clarify where we may not be meeting eye to eye here. She's not talking about the duty or the standard of care because this isn't a medical malpractice case. So the record is not going to reflect some of those terms of art that we are expecting in a med mal case or in a medical negligence case. But she does, Your Honor, she does concede that it's her job to confirm there are no contraindications to proceeding with surgery.
Well, can I ask you a question? I'm looking at the district court opinion, and the district court opinion said, looking at the testimony and evidence in the light most favorable to Dr. Robinson, said sometime before the timeout, Duncan interpreted the intraoperative TEE and discussed the results with the plaintiff. During this conversation, the plaintiff was never made aware that patient M had moderate AI. So even if she has a duty, why isn't the evidence viewing it in the light most favorable to her such that she did talk to Dr. Duncan about it and discuss the results and was told there was no severe AI? Or was certainly not told there was anything, that it was certainly was not told it was moderate?
So in the joint appendix on pages 112, 117, and 129, I think we'll get the answer to these questions. Yes, there is. Wait.
Now, you understood what I read you were the findings that the evidence that the district court's pointing to in the light, taking it in the light most favorable to her. You understand? This is district court pointing these things out. This is not just some evidence somewhere in the record.
And yes, Your Honor, thank you for that clarification. What I'm directing the court's attention to is the fact that, yes, the district court concludes, based on the evidence, that she was not aware before the sternotomy began, the results of the TEE. That is viewing the evidence in the light most favorable to Dr. Robinson, because Dr. Duncan says he did tell her. In fact, he says that there was never a question in his mind. It was so obvious and clear a medical student.
Don't you understand that for us reviewing a summary judgment decision, we don't look at what evidence is on the other side generally, unless it's virtually uncontroverted. We look at the testimony and evidence most favorable to the non-moving party. And that's what the district court did here. And that's the result you get when you do the job as properly as the district court did, at least in that respect.
Yes, if I understand you, I think we're in agreement that what the district court did was view all the evidence in the light most favorable to Dr. Robinson in the most generous fashion it could to Dr. Robinson, and still concluded that the statements by Dr. Williams about Dr. Robinson's role in the unnecessary sternotomy were not false.
Okay, could I ask you a question about that now that you mentioned it? Where is the evidence pointed to by the district court to support the opinion that she proceeded to surgery with an incomplete understanding of Duncan's interpretation? Where is the evidence that she relies on to make that conclusion? And point to me on the page in her opinion that shows that, please.
Your Honor, that statement, as I understand it, is the inference drawn by the district court in response to the evidence and all inferences in the light most favorable to Dr. Robinson.
I know, but I'm looking for what it specifically shows that she had a misunderstanding, an incomplete understanding.
Okay. And so I'll redirect you to Joint Appendix pages 112, 117, and 129. And on those pages, Your Honor, what you'll find is that Dr. Robinson says that she doesn't remember Dr. Duncan telling her that the aortic insufficiency was moderate based on the intraoperative TEE.
I think the district court found that he did not tell her that the evidence was that he did not tell her it was moderate. Isn't that right?
That's correct. That's how the district court viewed the evidence. Yes. And so the point is Dr. Robinson insists that it's not her responsibility to read the TEE, but she admits that it is her responsibility to confirm there are no contraindications to surgery. And so because she also admits that the results of the TEE can serve as a contraindication to surgery, the fact that she proceeded with the sternotomy, she cracked open the chest of a woman without getting an explicit answer from the person in the room.
What about the expert report of Dr. Blitz? This is at 458. He says acceptable practices for cardiothoracic surgeons performing a valve surgery can range from delaying the chest incision until the TEE is complete and interpreted, the results related to the surgeon on the one hand, to, on the other hand, simultaneously proceeding with the chest incision while the TEE is being performed on the other hand. Any of these practices are well within the standard of care for the cardiothoracic surgeon. That may not be right, but that's evidence that proceeding with the surgery without knowing like the TEE results is within the standard of care.
That may be true, Your Honor, but that's not the inquiry before this court. It's not about whether she met the standard of care.
But they have two theories, right? And one theory is it's false and defamatory to say I misread it because I didn't read it. Another theory is it's false and defamatory to say that I engaged in malpractice. It's false and defamatory to say I had an obligation to do something and I didn't do it. I admit I didn't do it, but I had no obligation. Why is that not false and defamatory?
Because sorry, I'm looking for a word and it's not coming to me. I know it's natural to want to bootstrap the med-mal issue to the defamation. And I don't think we need to, but even if we do, we can, because she's the only surgeon in the courtroom who's holding a knife. And before she makes that first incision, she says that it's her responsibility to confirm that the intraoperative TEE does not provide any contraindication to proceeding with surgery. She failed to recognize, she failed to ensure she had a clear understanding of the intraoperative TEE, and therefore the statement by Dr. Williams is not false.
Thank you, counsel. Mr. Gresham, you got a few minutes if you'd like them.
I think I saved 2 minutes, Your Honor. The question is, where did Dr. Williams make the defamatory statement? I will tell you it continued from the day of the surgery to April 14, 2018, when he is writing to the medical board. And he says, when he asked how this could have happened, I did respond that the board certified chief of cardiac anesthesia, Duncan, and a board certified cardiology surgeon, Barbara Robinson, failed to recognize the findings of the inoperative T. That's on page 639. There are other places, and I'm sorry, rather than just cite the record, I will ask you to take a look at JA 362, 1639, 1239. It is replete from the day of the surgery. And the last thing that the court needs to know is, remember that Dr. Williams acknowledged to her the day of the surgery that he hadn't looked at the first TEE.
But why is that relevant to whether what he said about her is false? I mean, that might be relevant if somebody's suing him for malpractice, but
No,
what does that have
it's
to do with
him
this?
pointing the finger elsewhere. It's him now
Like
saying,
motive for saying something false, but
Yes.
it has nothing to do with whether it's false or not.
no, it goes to the motive, and motive is something that in this case you can bring out. What is the motive for saying these false things? The motive was he had not done his job. And by the way, if you look at Dr. Duncan's deposition, he also says she may not have heard me when I made my initial statement about the intraoperative TEE because of what's going on in the room. And she states, and there's no evidence to the contrary, that typically when Dr. Duncan leaves, the first thing he does is talk to the chief surgeon. But he didn't do that day because of the three events. But he ends up being told that he had misread the intraoperative TEE to say it was severe, and only Dr. Williams saved the day. Our evidence is she went out and told him what she knew. This is showing it's moderate. He didn't know about the analysts, and he says that's one of the reasons I didn't do the surgery, something he had not discovered. So this is a case for a jury to sort out. There is evidence clearly that Dr. Williams can bring, but there is a lot of evidence that Dr. Robinson can bring in this matter. And thank you, Your Honors.
Thank you, Mr. Gresham. Ms. McHenry, we certainly appreciate your assistance in the case. We'll let you all leave, and we'll bring in counsel for our next case, 19-4812, United States versus Daniels.
And may it please the court. Detective McKinney admitted that when he arrested Mr. Daniels in this case, he did not have a legal basis to search the car. So he testified that he and the officers devised a plan to develop what he described as CYA for a search. We are asking this court to hold that the officers' plan, which included unmirandized questioning of Mr. Daniels and providing misleading information to Enterprise, ran afoul of the Fourth Amendment.
Mr. Carpenter.
Yes.
I hate to interrupt you this early.
That's okay.
And I always look forward to your arguments, but there's one question I think I need to get cleared up from my way of thinking. When I start looking at search and seizure questions, the first thing I look at is whether or not the petitioner has established standing. And I don't see any testimony in this evidence, or evidence in this case to establish standing. So how would you have me deal with that problem?
Sure, Your Honor.
It's a problem for me, maybe not for you, but would be a problem for me.
Well, it would be a problem for me if you viewed the case that way. So first of all, I'll acknowledge you're correct. There is no testimony. So there's to establish that he had permission from the driver of the car, the authorized driver on the rental contract. We acknowledge that. What we do have, however, and the reason we think we've met our burden to establish the reasonable expectation in this case is assertions were never disputed throughout the entirety of the proceedings below. So the district court relied on those factual assertions at Joint Appendix page 61 in the court order, which noted Mr. Daniels' assertion that he was driving with permission. And then if you look at Joint Appendix page 15 and 16, which after Byrd came out, let me back up. After Byrd, the parties agreed that further proceedings were needed because the rule from Wellens had been overturned. We reasserted the same positions, and at Joint Appendix page 115 to 116, the government in its response argued only abandonment with respect to the reasonable expectation of privacy inquiry. They did not assert or contest the factual proffers that were made that he had lawful permission from the driver of the vehicle. They said only that disclaiming ownership abandoned, quote, any expectation of privacy that may have otherwise been recognizable under Byrd. In other words, they acknowledged in their filing he had the initial Byrd.
Well, when they say any exercise, that's not acknowledging that it's there. I mean, I'm curious about that. This is sort of an interesting point. I mean, have we ever held that you can rely on an attorney proffer to establish standing? I mean, the whole sort of premise of these is that you've got the factual burden to do it, and it'd be really helpful, I suspect. I mean, you know this well as a defense lawyer, to be able to say, Judge, we don't want our guy to testify in the suppression hearing. I'm just going to proffer that these are the facts, right? I mean, that oftentimes I think defense lawyers would like to do that, and that might be appropriate. But when you have to actually have a stipulation to do that?
So, Your Honor, I agree. I don't know of a case that this court has that about proffers in that context. I think the rule it does fall under, however, is the rule that this court will not consider in the first instance arguments that were not made by the parties below. And here, the government below did not make either a factual or a legal argument on this point. Again, maybe it did not concede, but it at the very least assumed that he had the original expectation and said that it didn't matter based on the disclaimer. And I would point out that if the court allows the government to win this case on that issue, it creates what I would view as a very serious risk of sandbagging or gamesmanship. And while that may benefit the government, in this case, as a defense lawyer, there will be cases in the future where it would benefit us because, as the court well knows, it is fairly common practice in district court for proffers to be made by attorneys at suppression hearings, at sentencing hearings, where the facts at issue aren't in question, aren't disputed, and it saves the court from, it streamlines the process. It saves the court from needing testimony from case agents or particular witnesses.
There'd be a difference in the sentencing. I mean, I think you could separate the sentencing context where we often use proffers, right? The attorney stands up and talks about the guy's family without requiring testimony. I don't think you would have to go so far as to say you can't use a factual proffer in sentencing where we have much more relaxed standards. But, you know, the Supreme Court, when sort of established this rule that you can testify at the suppression hearing and that evidence can't be used against you at trial, sort of seems to rely on the need to actually put evidence on.
So, Your Honor, again, if the court views it that way, I can see that we are, we lose at the threshold. I don't think it's a good rule for the court to establish because of the risk that it creates for sandbagging in a case like this one. And I would point out, again, this was an undisputed factual proffer that was made in the initial motion in November of 2017. The hearing in this case was 2 years later. So for 2 years, the case proceeded through an initial motion, a response, an initial order, a motion to reconsider, a response to that, and a hearing. At no point was this fact ever disputed. And had it been, it would have been very easy to put on testimony. You wouldn't even have had to worry about the defendant's own rights about testimony here. You could have simply put in testimony from the driver, the authorized driver on the rental contract. It would have been a very simple problem to solve. It streamlined the hearing to not have to have that additional witness testimony. And I think it would be improper to allow the government nearly 4 years later, when it filed its opening brief in this, or its response brief in this case in August of 2021, to raise an issue that the parties had not disputed in the nearly 4 years of litigation preceding it. So I do think it falls under the basic rule that where the argument is not made below, it should not be considered by this court on appeal.
And does it, and I don't have JA 61 before us, but your representation is that is where the court found that he effectively was a permissive user of the vehicle?
Correct. So this was the pre-Byrd decision. It's a 2-page order. And it says here, according to the defendant's motion, he was using the rental car with permission from its authorized driver. However, he is not alleged that he was listed. Then it goes on to say under Wellens, those factual allegations don't state a reasonable expectation of.
So that's the pre-Byrd question.
Correct.
In which case, the proffer didn't matter then because it wasn't sufficient.
Under the existing law at the time, right. I mean, this case was brief.
Is there anything post-Byrd from the district court that suggests to us that he was a permissive user? Because you might imagine if the court made the finding, maybe that'd make a difference. Not sure.
So there is not a specific ruling on it, though. If you look at the ruling that the district court did make, it was premised on the assumption. It never challenged the factual proffer. That's why the analysis of the disclaimer was important, because everybody was operating on the assumption that he had the reasonable expectation under Byrd, but that it was disclaimed as a result of the un-Mirandized statements. But no, I acknowledge there's no specific ruling.
Can I ask a different question? And I don't mean this as a gotcha, and I'm happy for you to just say I don't know the answer to that question. But on the there's sort of a gauntlet you've got to go through. But let's assume for a minute that you've established a Miranda violation, and the question is whether it renders or excludes the statement from a pretrial proceeding. We issued a decision in 2005 called Burrell versus Virginia, where are you familiar with this? I figured you would be. I've never managed to surprise you before. I didn't think today would be the day. And so we conclude there, based on a reading of Chavez that may or may not be exactly the way you have to read Chavez, that the Fifth Amendment claim failed because he does not allege any trial action that violated his Fifth Amendment rights. Why doesn't that, right or wrong, bind this panel on the question of whether loosely the exclusionary rule doesn't apply to pretrial hearings?
Sure. So I think the reason it doesn't is that when the court used the trial action in that case, if you look at that language, if you look at the broader context of Burrell and the other language, it makes clear what the court is talking about there is the, quote, courtroom use that was talked about in Chavez. So in particular, if you look at footnote 4 in the Burrell decision, it says, it says that in oral argument, Burrell's counsel affirmed to the court's question that Burrell only claims that his constitutional rights were violated at the time the summonses were issued, not at the time of the trial. So there was no allegation in Burrell that they were used at any other point in the proceedings. So I think trial action was used there, kind of a shorthand for what the Chavez court described as courtroom use.
All right, so that's so that's one way of saying the court need not have relied. It could have had a narrower rule, right? But it announced the rule as trial. And it's hard for me, I'm bound by this in the same way that you are. And it's a little hard for me to get my head around how I can read that trial, as you suggest, to say trial and pretrial proceedings. right? I mean, you know, Judge, I believe it was Ludig that was writing it. You know, those are the words that he chose. It is maybe a rule that you don't like, but it's still the rule that he announced as the rationale for the decision.
That's true. He uses the phrase trial right. I don't think it's a binding holding on the distinction of trial right versus courtroom use as the governing question, because that issue wasn't raised or briefed in the case. So I think that I just don't think it was an issue that was needed to be decided or that was decided. I acknowledge the language is there. I just don't think when you read the full context, it walks through the two different rationales in Chavez and then in quotes trial action. But I don't read that as definitively resolving an unresolved, unbriefed question that was.
So then what do we do then in Nichols where the court comes back and says, you know, it sort of talks about it. Now, this is probably not a holding, right? But in Nichols where it says, you know, the exclusion from the government's case in chief at trial will provide adequate deterrence, right? It's sort of that by itself might not, you know, be sufficient, but that's exactly what Burrell's telling us, right? Again, it's back to this idea of the trial and there even more narrowly, the case in chief at trial because of the possibility to use in cross-examination that we know about. When I read that, doesn't that support the sort of natural reading of the word trial in Burrell versus Virginia?
I don't think it does, because I think what Nichols is telling us is that when you're outside of the case in chief at trial, then we apply this balancing test and decide whether deterrence is needed in the particular scenario. So in Nichols, it wasn't, because there was already a deterrent effect created by.
Right, but the conclusion that is made in Nichols, and I get they balance lots of things, but the conclusion is that it's enough to exclude it from the case in chief at trial because that provides ample deterrence. I mean, that's sort of, they do this balancing, but that's sort of the conclusion. Ergo, it's okay at sentencing. Or I'm sorry, it's okay at sentencing to use the Fifth Amendment material.
Right, but I think that it's still a context-specific balancing in that case. Is excluding it from sentencing necessary where there is a deterrent effect created by the exclusion from the case in chief? And that's what distinguishes our case, because here there is no deterrent effect at all if these statements are merely excluded from the case in chief. And that's because the primary purpose of these statements is to establish the validity of a search under the Fourth Amendment. That issue is one.
No, but they would have also been, they also could have been introduced at trial to show, you know, ownership of the gun. I mean, imagine, for example, that the DNA didn't come back, right? So the DNA didn't come back. Do we think they would have used those statements about the car? I mean, they were inculpatory statements independent of the abandonment issue. No,
I acknowledge that could have been a secondary use of them if the DNA evidence weren't there. But I still think the primary purpose, and that's how they were used in this case. And we know also from Detective McKinney's own testimony, that's his intent for how to use them from the beginning, is that he was doing this questioning.
His intent doesn't really matter, right?
That is true, but I think his intent is relevant when the primary question we're asking here is there a need for deterrence? And I think in that scenario, intent is relevant because it shows us that police officers will, if they are allowed to do so, use unmirandized questioning to justify Fourth Amendment searches. That's why we think there is a need for deterrence here to protect against that. And so that's the reason we think this is a different case than Nichols or than Burrell. Thank you. I realize my time is running short, so I'd be happy to answer questions about the other issues in the case. You know, our position is, you know, that first on the Miranda issue, as we said, we think the government can't rely on those statements. Second, we think that Enterprise's actions here don't provide valid consent because they arose from police deception as to the true nature of the situation here. And third, we think that the inevitable discovery doctrine doesn't apply because if Enterprise had been informed of the full facts, they would not have repossessed the car when they did. Happy to answer other questions. If not, I will.
Judge Richardson, I can't hear anything. anybody's talking, I can't hear them.
region of interest. We need some help.
I'm happy to give him hand signals if that makes it easier.
I'm sorry, I've never had to do that before. Do you know how to do that?
I can hear you now.
Great. We can manage. I'm sure Mr. Enright and I can manage. I'll give you some hand signals to the extent it's relevant. It's just fine. We appreciate your help. We know how unbelievably difficult it is to keep all these technical things moving forward. And so I'll just start a timer up here for you, and we'll estimate about an approximate time for you, if that's all right.
Fine with me, Your Honor.
All right. Thank you. Mr. Enright, we're happy to hear from you.
Thank you, Your Honor. The district court properly denied Daniel's motion to suppress for essentially three categories of reasons. And I think the first one is one you discussed earlier, which is standing. The defendant did proffer that he, in his papers, that he had possession of the rental car with permission from the renter, who was Erica Baldwin. And our response to that was not, okay, that's fine, then we don't need to have a hearing on it. Our response on page 115 of the joint appendix, which I believe counsel referred to, was a defendant must submit persuasive evidence of a privacy interest in a vehicle to have standing to assert a Fourth Amendment challenge to a search or seizure of the vehicle. In other words, you have to present evidence of it.
Was that pre or post Byrd? 115.
This particular paper was post Byrd. But we took the same position both times, which is, that's fine. I don't think we didn't expect that they wouldn't call Erica Baldwin or present this evidence, but we indeed put them on notice. They needed to present that evidence. And
at any point, so I understand that that point, but Fourth Amendment standing is not jurisdictional, right? And so is there anywhere, and I didn't really see it below, but I want to hear from you what the best place is, that you contested that like permissive possessory interest, right? Because there was some testimony that he had a possessory interest, right? Because y'all saw him driving around with it, right? That's part of the reason you asked him the question about where it was or whether it was his. And by you, obviously, I refer to your colleagues. But is there anywhere where you argue that the defendant failed to put forward the persuasive evidence that his possessory interest, which was established, was permissive?
No, Your Honor. I'm relying on the doctrine that this court can affirm on any ground fairly supported by the record. Now, that's not a rule that's defense or government specific. It's appellee specific. This court can affirm on any ground fairly supported by the record, and the defense would, of course, be able to take advantage of that rule if they were the ones, if we were the ones challenging the court's ruling. And it, I think, is an important rule because here we don't just have the lack of evidence. The defendant took the position in his papers throughout the whole time that Mr. Daniels had possession of the car. He had a possessory interest in the car while he was sitting in that hotel room, and that's why he has standing. And then at the hearing, he decided to do a 180 and say not only did he not have possession, but that it was deceptive for the police officers to even suggest as much to Ms. Ziteroff. And they maintain that position.
Mr. Enright, can I ask, here I am over here.
Certainly, Your Honor.
Mr. Carpenter makes a very good point that or at least he implies that he might have been sandbagged, that when this hearing started, he had made the representation, or the representation had been made through counsel as to what constituted a reasonable expectation of privacy, where his standing came from, and the government doesn't say anything, doesn't do anything, doesn't object to going forward. You just go on and call your first witness. Now, how can you now complain that he didn't establish standing when you really made little to no effort to require him to do so?
Well, I disagree, honestly, with the factual premise, Your Honor. We did say in our response on page 115 of the joint appendix, the defendant has to present persuasive evidence of that. Now, we didn't belabor it.
I understand that, but you just buried a sentence in the middle of a long brief. I'm talking about you get in the courtroom, you're ready to go, your witnesses are there, and you say to the judge, I don't have to put up one witness till he's put up a witness establishing standing. But instead, you don't do that. You just acquiesce. I don't know if it was you or not, to tell you the truth, Mr. Enright, but the fact is that this problem was not called to the district judge's attention as far as requiring testimony from the defendant.
That, I think, is true, Your Honor. And we should have raised this issue probably, Your Honor. I don't think that we're required to for this court to affirm, but obviously that's a discretionary call. What I will notice, and I don't know that I have an excuse for it, but I do have an explanation, which is that we were very surprised. The defense, we thought the defense would call Erica Baldwin to establish lawful possession. Instead, he changed his position. He said the exact opposite of what he said in his briefs, which is there's no possession. Possession was unlawful, or there was no possession at all. And the defendant or the officers, when they said that Daniels was in possession, that was actually deceptive. So we weren't expecting there to be any dispute about possession. We weren't expecting that, and that was something that the defendant introduced. So I think if there was any sandbagging, it probably went in that direction. But I don't want to belabor that point because there's other issues we did discuss.
On this expectation, so I've sort of thought about the expectation of privacy in sort of two different time points. Right? One is at the when he's arrested, sort of at that moment, and that's the one that doesn't seem like there was a lot of discussion below about. But there does seem to be discussion about whether any expectation of privacy that he did have at that moment continued after the tow. And so that question of whether his expectation of privacy existed once towed, that issue was argued and debated significantly below.
Yes, Your Honor, absolutely. And I think there's two reasons it wasn't there. That the expectation, to the extent there was an expectation of privacy before the towing, it was gone after the towing for two reasons. The first is we had undisputed testimony that the rental car contract expired and the rental car company repossessed the car. The expectation of privacy is accompanied by a right, or ordinarily what attends it is the right to exclude. Obviously, his right to exclude other people from that car, to the extent he had any before, was gone after Enterprise took its car back. And the second one is his own abandonment, which nobody contests. It had the effect of abandonment if it were admissible. His statement that, "Oh, I don't know anything about that Dodge Charger," and for two reasons.
Can I ask a slightly different version of that? And I understand that the idea was whatever possession he had is now sort of extinguished, and there are two different reasons for doing so.
Yes.
If we rely on the attorney's proffer for this idea that he had a permissive possessory interest, looking at JA 1718, which your counsel pointed to, can we also rely on that for the suggestion that the falsity of his possessory interest to Enterprise was not in fact false?
Absolutely, Your Honor. The defendant cannot say that it was false for Mr. Kipp to say that Daniels was in possession of this car, while also saying that he was in fact in lawful possession of the car and resting on that. It has to be one or the other. And if that proffer is something the court was entitled to accept, then obviously it settles the possession issue. And that is dispositive of this appeal because there's no dispute that she gave consent. And that consent was a valid basis for allowing the search. And the only basis for challenging that is the idea that it was somehow deceptive. And that's a far cry from the standard, which is voluntariness. There's no possibility that that statement undermined the voluntariness of the consent, both because it was clearly not deceptive. Ziteroff testified. What did he was in possession mean to you? She testified, I understood that to mean they placed him driving the vehicle. That's exactly what they did. They placed him driving the vehicle not 10, 12 hours before. And that's what she said she cared about. Well, was he an unauthorized driver and was he driving the vehicle? There was no deception there. There was certainly no coercion or anything that would undermine the voluntariness of Ziteroff's consent. But perhaps more basically, the officers didn't get their consent from Ziteroff. They got it from Chris and another Enterprise employee who consented after they saw a firearm. So I think that issue, independently of any Miranda issue, independently of any standing issue, supports affirmance of the decision to deny the motion to suppress.
Don't feel any obligation to if you've not reviewed it. I'm not asking you to make things up, but if you've read Burrell in Virginia and wanted to comment on it, I'd be happy to hear your take on it. You heard our discussion with your colleague.
Certainly, Your Honor. I'm familiar with that case, and I do believe the court did say a trial right. It's used that term in other contexts too, in the Riley decision more recently, and that's meaningful because, as the court said in Elstad, where the Miranda presumption, and it's a prophylactic presumption, is irrebuttable, where that attaches is in your case in chief at trial. And that goes right to the heart of the issue, because Miranda is designed to deter custodial interrogation, which means words or conduct reasonably likely to elicit an incriminating response. Well, where is an incriminating response going to be useful? It's going to be useful at your case in chief at trial.
Well, I mean, it's also useful in lots of other circumstances, right? Like getting search warrants, or maybe going to the grand jury and getting an indictment, or maybe at a suppression hearing, or maybe at sentencing. I mean, it's used. I mean, we all know that it is used in lots of other places. The question is, you know, we might say is there sufficient deterrence from the case and trial? But it's not that it's not useful elsewhere, right?
I'm not saying it's not useful, Your Honor, but I'm saying it is a big deterrent effect to say that your incriminating statements you've elicited can't be used to prove the guilt of the person at trial. And what this court said in what I think the Supreme Court has said in several cases, but what this court said in Nichols is that's ordinarily going to do the trick. And the case at issue, of course, was the sentencing. Even more so, I think that's applicable to a suppression hearing, because a suppression hearing is ordinarily, at least a Fourth Amendment suppression hearing, where the issue, what's being suppressed, is ordinarily going to be reliable physical evidence. There's no concern that you're suppressing a statement that might be incorrect because of coercive pressure. You're suppressing reliable physical evidence. And there, the cost of suppressing that evidence is really high, because that's really reliable evidence that the jury should ordinarily be able to see. And the incremental deterrent value, that is the deterrent value of suppressing it beyond excluding it from the case in chief, is really low. It's no greater than it is certainly at a sentencing hearing. So to the extent you get to the balancing test, I think that balance under Nichols clearly comes out in favor of not extending the Miranda rule to the suppression hearing. But I don't think this court needs to go that far, because I think we have the Patain decision, which holds that you don't suppress reliable physical evidence because in order to deter Miranda interrogation. And I don't think you have a Miranda violation here, because a statement, when you know the person's been driving a car, hey, what about that car, is not reasonably likely to elicit an incriminating response. Now, the officer testified he had a hunch maybe there was something in there, but this court held in Johnson, you know, the possibility that it might be incriminating isn't enough. And in fact, Johnson gave it as an example. There are some questions that don't have that effect, and an example it gave was, hey, is that the hotel you're staying at?
But do we really think about whether it's incriminating as the inquiry? Because and the reason I worry about that is, like, imagine the scenario where I happen to know, you know, based on witness testimony that, you know, a Mr. Enright who works in the U.S. Attorney's Office has committed this crime. And so you're going, and somebody shows up and arrests you based on their belief that you're Mr. Enright. And I come up to you and I say, what's your name? Right? I know that that is incriminating, right? Because I know that Mr. Enright is the one who has committed the crime. So that might well be designed and will provide incriminating information. But we have not thought traditionally of the name, for example, as being something to requiring Miranda warnings, but it's not because it's not incriminating or might not be incriminating.
That's correct.
Right? It's because it's somehow ministerial in nature.
Yes, Your Honor. And there's a separate category of information, which is generally routine booking questions like that basically Miranda doesn't get into, even if it is, for example, like an identity theft case where, oh, your identity is pretty important to culpability. And I think I don't know that the court needs to go that far in this case, but I do think it falls in this category when you're talking about the property that we know is associated with this defendant. What's the deal with that? You know, asking him, hey, were you driving that illegally, or is there any contraband in there? That might be a little bit further, but all the testimony establishes, he asked him basically about this car that they saw in plain view. And I do think it's fair to say that falls within the ministerial exception, essentially, and I don't know if it's characterized as an exception, but the ministerial questions doctrine of Miranda. That said, for so many reasons, I don't think the court needs to go that far. other issues we have is the final category, I suppose, or two other things. Sorry to get ahead of trip over my own tongue, but Detective Barsh testified without contradiction that the officers at Enterprise informed her there was a gun, or the employees of Enterprise informed her there was a gun before there was any search. That establishes probable cause to believe there's evidence of a crime in that car. And that alone, independent of...
But isn't there contrary evidence to that? I mean, they're like a little bit of a mess on whether whether they found the gun first or whether the officers found the gun. I mean, it seemed like there was a little bit of confusion about that. And for us to, we could affirm on anything clear in the record, but that doesn't seem so clear.
Your Honor, certainly the defense included a lot of rhetoric in his submission about that. But I think if you read Detective Barsh's testimony, it really is uncontradicted. Nobody testified that anybody searched this car before the officers were informed there was a gun. Detective McKinney didn't hear the conversation with Detective Barsh, but both of them explained he was on the phone. It's not like he should have heard that or there was any contradiction in it. But I agree, Your Honor, and certainly the court doesn't have to affirm on that ground. There are plenty of other grounds, including one which this court heard not only uncontradicted, or the court heard not only uncontradicted, but undisputed testimony, which is the police would have inevitably discovered the gun through lawful means in any event. Both Ziteroff and Christ both testified, here's our standard procedure. We tow it back to this lot. We look at everything that's in there in case there's property that's left behind. And if we see a gun, we secure it and call the police.
Is there a case, I mean, I understand the logic of it, but do you have a case where we've applied inevitable discovery based on the policy and procedure of a private actor, right? I mean, we tend to think about inevitable discovery as you got it in the impound, right? And we search every car, and so that's the inevitable discovery doctrine. Have we extended it to, a private actor's policy?
This court, as far as I know, I don't know of a case from this court. I know the Kennedy case from the Sixth Circuit. I know of another decision that I'm blanking on from another circuit, but I don't know of one in this decision. But what this court has basically said is it's relatively simple. We have the burden. Can we establish that we lawfully could have obtained the evidence, but for the allegedly illegal behavior? And two, would we have? Would that inevitably have happened? And
does that depends on you prevailing though on the sort of your opponent's claim that you misled Enterprise, right? And so I want to understand the framework. If you had misled Enterprise, I'm not alleging that you have, but if you had, then inevitable discovery wouldn't save you because Enterprise would not necessarily have towed the car. Maybe the renter would have come and picked it up.
I disagree with that, even accepting the premise, which I definitely don't agree with. Accepting the premise that that we misled Enterprise, because misleading Enterprise isn't a violation of the Fourth Amendment, and certainly not a violation of Daniels's Fourth Amendment rights. So you can't say that what Enterprise did was the fruit of the poisonous tree grown from a Fourth Amendment violation. If you believe that if this court concludes that stating to Ms. Ziteroff that he was in possession of the car and now it's sitting at the Baymont Suites, because we know he communicated that to her, is somehow deceptive, it's kind of a red herring, because that doesn't make the conduct the product of unlawful behavior or anything unconstitutional. Maybe the police shouldn't have used that word. I think that's probably not correct. But I think it was perfectly acceptable for the court to use that word, but that doesn't make the inevitable discovery doctrine inapplicable. The inevitable discovery doctrine asks what would have happened but for the Fourth Amendment violation. And the only Fourth Amendment action, the only action regulated by the Fourth Amendment in this case was Detective McKinney's anyway through their ordinary procedures. If this court has no further questions, I'm happy to answer them, but if not, I'll yield the balance of my time back to the court.
Thank you, counsel. Mr. Carpenter, we're happy to hear from you for a little bit.
Thank you. So I'd like to start with a quick point about Burrell and then maybe transition to the deception point. I think that looking back at the case again, the key reason we shouldn't rely on Burrell to establish the trial right as the rule is because if you look at the flow of the analysis, Judge, I think it was Ludig, walks through under Chavez, there's the plurality reasoning, and then there's the Souter-Breyer reasoning. And then in the application paragraph, he goes on to say, well, he doesn't allege a trial right, so he loses under the plurality reasoning. But then the next sentence goes on to say, and he also loses under the Souter-Breyer reasoning. So I think this is very clearly an alternative holding that whichever of these two tests is the right test, this particular defendant loses. So I think referring to the trial right in that context, in the context of under either of these tests, he
An
loses.
alternative holding where they're both necessary doesn't render one of them dicta, does it?
No, but it doesn't render the decision to be deciding which of the rules is the applicable rule going forward. It abstains from that. It says whichever of these two rules controls, this particular defendant loses. That type of reasoning leaves for another day the decision of which of those two rules controls in a case where it matters. So I don't think that anything in Burrell can be read as weighing on either side of that. I would also add, this is somewhat adjacent to Burrell, but the trial right only line of reasoning has a huge textual problem because if you look at the Fifth Amendment, it doesn't refer to a criminal trial. It refers more broadly to a criminal case. And a suppression hearing is simply a piece and a critical piece of a criminal case. Otherwise, if we had structured criminal trials in this country differently, you could imagine the trial starts and then you have a sidebar at which you decide these types of suppression issues. And then it would be all part of the criminal trial. But we think it more logical to do it in front under the criminal rules of procedure. We do it first so that we decide the evidentiary issues up front and then we go to trial. I just don't think that that the trial right only logic makes sense under the Sixth Amendment, and I don't think under the Fifth Amendment, and it's not required under this court's precedent. I transition just for a few minutes to the deception point, and Judge Richardson in particular, your question about, well, if he alleges that he had a possessory interest based on the permission, does that also mean that what they said wasn't false or deceptive? And the point, I think I have 2 points there. One is our view is that simply it is false to say that he had constructive possession when he lacked the keys. So we think the absence of keys is dispositive on the constructive possession question. But more broadly than that, I think that the focus on the falsity of that statement, which is certainly what the district court focused on in its ruling entirely, is a little bit of the wrong inquiry, because a statement can be technically false, but still be highly misleading. So for example, if I'd walked in here today coughing and said, don't worry, I tested negative for the Delta variant, that might be true. But if I had also tested positive for the Omicron variant, my statement would be very misleading to the court. And I think that's what we have that happened here. Even if what Detective Kipp conveyed to Ms. Ziteroff was technically true.
Respond to your colleague's point that even if it's misleading, that's not a Fourth Amendment violation.
So I think it is. And the rule I would point to, the case I would point to is the Pagan-Gonzalez case from the First Circuit, which walks through a bunch of Supreme Court and other precedent that establishes the principle that if officers, when acting in their official capacities, not undercover, but when in their official capacities, they use deception to secure consent for a search that would otherwise be unlawful, that consent is invalid. And that's exactly what we have. That's exactly what we have here. The officers used deception, they omitted critical information, and they created a very apparent misunderstanding about the true nature of the situation. And by doing that, they induced Enterprise to repossess this car and ultimately consent to a search. And so again, just the things they did, they omitted the two key facts here, that he was not arrested in or near the vehicle, he was instead arrested inside of a hotel room. And secondly, that he did not have the keys to the car. So those were omitted.
More correctly, they didn't find the keys to the car.
Correct.
The only fact that we know is that they didn't find the keys to the car.
Correct. They were not in his person, nor were they in his hotel.
That they
were not found. So I suppose the officers did a poor search, but in any event, more importantly, if you look at Joint Appendix page 227, and my colleague quoted this language, but I think he overlooks its real central point, which is Ms. Ziteroff understood what was conveyed to her to mean, quote, that he was driving the vehicle. And the present tense there is critical. She understood that he was driving the vehicle, not that he had driven it at some point in the past and then went to bed and slept in his hotel room until he was arrested.
She understood that he was driving. That triggered the enterprise policy that when someone is driving our car and is arrested and the car would otherwise be left abandoned, we tow it. And if the police want to search it, that's fine. If they had given her full information, it would not have triggered their policy. There is no evidence in the record that if they had known the full facts that the authorized renter of this car is out there somewhere, presumably has the keys, that they would have repossessed the vehicle. Instead, we can assume they would have called the authorized renter and said, hey, there's a situation with our car. Do you still have the keys? Are you planning to return it? What's going on? That's why the government can't meet its burden under inevitable discovery, because without the misleading conduct here, there's no evidentiary basis to believe that the car would have been repossessed when it was and ultimately consented to the search.
Thank you, Mr. Carpenter. Oh, sorry,
One quick
Judge
question.
Traxler.
Mr. Carpenter, I'm looking at the findings of fact that the trial judge made in ruling on this, the validity of this search, and his findings is that Mr. McKinney's provision of information to Enterprise was not false. Now, what does that do to your argument then?
So I think it does two things, Judge. The first is it subjects us to the clear error standard of review for that particular finding. Again, that's where our position is that the absence of the keys renders that finding clearly erroneous. But the other thing it does is that the judge's findings of fact simply do not address the broader question of deception, which can, as I pointed out, be separate and apart from simple falsity.
Okay, thank you.
Thank you, counsel. We obviously are not going to come down and greet you, but we certainly appreciate your argument today and help on this case. As y'all leave, we will then bring in counsel for our final case, 24019, United States versus Elbaz. Counsel, we're ready when you are.
Thank you. Your honors, may it please the court, Eric Brignac for Lee Elbaz. And this case obviously raises a lot of complicated issues about both the conviction and the sentencing related to the government's decision to prosecute this case domestically in the interest of our limited time and the amount of issues in this case. I wanted to start with the issue of the extraneous information brought to the juror number 9, which he then brought into the jury room, which I think is the most compelling issue in this case. In short, the Remmer presumption applies. The government did not rebut the Remmer presumption. This court must vacate that jury verdict. The situation that happened.
Can you start with the first part of that? I'd love to talk to you about both of them, but start with the first part. because it's not directed at the juror and it's not the juror's own action. And so when we look at Rimmer and it requires a private communication, contact, or tampering, why do we think this type of sort of overhearing gossip qualifies for Rimmer presumption? Now, it might well mean that, prejudice can be established, but why do we think Rimmer applies in this context as opposed to context in which there is private communications that are directed at the juror?
Two reasons, Your Honor, one based on this court's precedent and one based on the reason for the presumption. I think the Barnes case is the most relevant precedent on point for that. As Your Honors remember, that was the case where exhibits were completely inadvertently sent into the jury room. There were exhibits from a suppression hearing. The jury should have never seen them. And the Rimmer presumption applied. In fact, the Rimmer presumption applied.
Right, but that's a private communication, right? Like if I'm sending, it's like if I sent you mail, right? So if I write a letter and I send it to you and you receive it, right? Like that's a communication to you, a private communication to the jury. Like that seems, not dissimilar to, the prosecutor, grabbing somebody on the way out the door and saying, this guy's really terrible or whatever it might be.
I would respectfully disagree with that, Your Honor. I mean, the exhibits that were sent into the jury room were not done in Barnes with any ill intent, with anything other than inadvertent. So I think the Barnes analysis would have applied if those exhibits had been put in an anteroom and the jury had been sitting, cooling their heels in this anteroom and noticed these exhibits. It would have been inadvertent and it would have prejudiced them, just like it did here. And I want to say,
okay, but that's okay. Give me the second reason. Assume I'm not convinced by that one. Go to the second one.
There are some doctrines in the law that are meant to discourage malfeasance from a party. There are some doctrines that say if you intentionally or knowingly or negligently do something wrong, we're going to hold it against you. We're going to hold it against your client. That's not what's being protected here. What's being protected is that Sixth Amendment right to an impartial jury. And, if Your Honors are familiar with Winnie the Pooh, it's all the same at the bottom of the river. If I fall down into the river, I don't care if I was intentionally pushed. I don't care if I slipped and fell. I don't care if the bridge was negligently constructed. Ms. Elbaz deserved a jury that did not have a juror who said, I heard this prejudicial information. It affected me. It made me think that acquittal was the wrong decision. I went into the jury room for an entire day of deliberations.
All right, so stay on the. I mean, I understand you want to go to that point, and I want you to get there. Do you contend that the Rimmer presumption would also apply to like a news report? So if a juror walked past a newsstand and it had an article and they inadvertently, right? Total inadvertence, right? But they look over and there's a news article, or they hear it on the radio on their way in, and they cut it off when they can, but they hear some portion of it. Is Rimmer applicable there? Because courts don't seem to think so, and I'm having a little trouble with that.
If there are cases saying Rimmer does not apply there, Your Honor, I'm not aware of them. I think Rimmer would apply. In Your Honor's hypothetical with this much more limited the case, it was a communication, but there was no substance. Rimmer did not apply. In United States versus Basham, it was one-way communication. The juror was communicating with the media. The juror was sending information out. The media members.
Those are two different parts of it. So Rimmer requires both like material information and it be a private communication is what it seems like to me. Those address the material aspect, right? Not the private communication piece.
Yeah, and Your Honor, yes, you're right. Neither of those address the private communication piece. Those are both about materiality. But what we're protecting here, Your Honor, is Ms. Elbaz's Sixth Amendment right to an impartial jury. This fundamental right. I mean, that's why this.
Then why did the court use the term, and I'll stop on this because I want you to talk about other things, but why use the term private communication, contact, or tampering if what they meant is any public or private information or any public or private communication or any information that you get, right? I mean, your reading of it, which, you know, I accept, reads out the words that Rimmer itself uses, right?
Well, actually, I think on the facts of this case, Your Honor, it need not. First, to answer your question, I do think Rimmer is broader than Your Honor is classifying it. But I also think that this communication that he overheard, which was not a news broadcast or something that the entire jury saw, it was two people next to each other. He overheard them. He understood what they said. He said it affected him. I do think that falls under Rimmer. And the burden then shifts to the government. And, you know, I do not think we have, I'd love to have a case exactly on point on that point, Your Honor. I don't, because this is thankfully rare. A situation where something, you know, we know a juror heard this. We know it affected him because he said it affected him. We know it affected him in a negative way. We know he brought it into the jury room for an entire day. And only after that did he think to bring it to the district court's attention. There are a lot of steps along that path that, you know, he could have taken, juror number 9 could have taken to prevent this from becoming the disaster it did. But he didn't take those steps. And I don't think the government can then rebut the presumption based on what we have. We don't know how he affected the other jurors. And I know the government—
Can we consider the testimony? I said I was going to stop, but I wasn't being truthful. Can we consider his testimony that it affected the way he thought during that one day under 606B? I mean, we seem to have say in a different context when the government tried to rely on the mental impressions of a juror. We said under 606B we can't do that. That you can't use that to rebut the presumption in that case. But you're trying to use it here to bolster the presumption. Don't we have to not consider that at all under 606B?
I disagree, Your Honor. And first, let me say, please keep asking questions. I care much more about what you care about than whatever I had written down here. Rule 606B on its own terms is about impeaching a verdict. And I did not, these cases are not in our briefs. There's not a lot of discussion. The 7th and 10th circuits, and I apologize, I don't think I have those cases in front of me, have each talked about how 606B does not apply pre-verdict. Now, the district court and the parties in this case, and I think Ms. Elbaz's attorney even mentioned 606. And I think everyone was operating under the spirit of 606B. Let's keep this jury as black a box as possible. Let's not look under the hood any more than we need to. But I would say, Your Honor, if you look at 606B, it is about impeaching a verdict, and that's not where we were in this case. The verdict had not happened yet, Your Honor. So I actually don't think that it was improper. The district judge obviously was trying to keep the juror from talking about what he thought and felt. But let's even say that we don't know. The fact that he was looking to acquit, I think this court can and should and must consider that. But let's say you decide that under the spirit of 606, you cannot consider that. I think we have still established a Remmer presumption that the government cannot rebut. Because what is still in there is this juror saying, yes, it affected me. Yes, I brought it into the jury room. It affected my 2 cents, what I told the other jurors. And that is why I think even the district court's valiant attempt to cure this, to ask the jurors to restart communications anew and the like, it doesn't matter. You can't put something out of your head if you don't know it's there. You know, the analogy I came up with this morning is if, you know, someone slips strychnine into this water and I drink it and I get stomach cramps, I go to the hospital and they say, you know, have you had strychnine? What have you consumed? I say, no. I completely and honestly say no. But, you know, if the poison's in your body and it's unknowable, it's actually harder to cure that. The poison, whatever went into the jury, we don't know. And it's sort of like the Lawrence case, you know, which was about the Wikipedia entry. And this court said, you know, because we don't know exactly, we know these jurors looked at Wikipedia. Wikipedia changes daily. We don't know what it said. That's a fact against the government because the government bears the burden. And so since we don't know what juror number 9 said, we don't know how much poison seeped into the jury, they have the burden of rebutting that, not just rebutting it, showing that there's no reasonable probability that's affected the verdict. They can't make that. Judge Wilkinson in the Stockton v. Virginia case, I think also talked about, at the end of that majority opinion in that case, and I would point out, that was a habeas case. So even in the face of the strong deference given to the state courts in that case, this court said that can't stand. And it was a more direct communication. Someone told the jurors, I think you should fry the son of a bitch. That was more direct than what we had in this case. But he talked about how the fact.
But also they told those jurors, and then those jurors went and deliberated and voted, right? I mean, they were the ones that voted. They remained on the jury, voted, I think in that case was the penalty phase, if my recollection is.
The death phase of it.
Right. And then only after the fact was it realized, right? And so it's the challenge I'm having, and I just want to make sure I've looked and I have not found a case where there's only one juror that's tainted with the actual outside information. That juror is removed and does not vote, and deliberations are restarted by the court. I haven't found any case of that scenario that suggests that you get relief.
And Your Honor, I would say I haven't, and I imagine if the government had, they would have found cases saying we don't get relief. This is a rare factual scenario, thankfully, and that's, I think, why we're having some trouble finding a case exactly on point. But I would say that what makes this case more like Stockton and less like these other cases like Basham and Bavette is that it was substantive information that he admitted. If he had said, he admitted he brought it into the jury room. If he had said, Your Honor, I'm a really quiet guy. On Thursday we deliberated, I didn't say much. Friday, I didn't say much. Monday, this was in my head, but I didn't say anything. And I was just a wallflower all 3 days. Then I think the government rebuts the presumption, because then there's no indication that the other jurors got this information. But just restarting the trial isn't enough. Again, in Stockton v. Virginia, Judge Wilkinson talks about this. You can't ignore the natural human tendency to want to go along with what you hear. In United States versus Barnes, the jury saw these exhibits. They didn't discuss them. The jury goes into the room where these exhibits are sent. They realize something's wrong. They tell the court. Court tells them to put it out of their minds. You weren't supposed to see those. Don't see them. And that wasn't enough. We said the jury just couldn't follow that instruction. Look, even in this case, we didn't raise it, Your Honors, as a point of error, but the government in closing in this case, and I'll point you to its Joint Appendix 4312 through 4319. They had an exhibit during their closing they put up on the screen for, I think it was 2 or 3 seconds, and it had not been admitted into evidence. So the defense lawyer says, the jury saw this, it wasn't admitted into evidence, we want a mistrial. District court said, this was pretty egregious, but this was a cumulative exhibit to stuff they'd already seen. It was only on the screen for 2 seconds. He told the jury to disregard it, but interestingly, Joint Appendix 4319, he said, I'm going to tell them to disregard it, but I'm not even going to explain what it was. Because, quote, it just sort of reinforces or creates a second wrong. It doesn't make it right. That was a recognition of the fact that when you have something, this is almost like toxic waste. It's almost nuclear. When you have something the jury's not supposed to see, what is an entire trial? An entire trial is basically deciding what these 12 people do and don't get to see. That's the entire apparatus we operate under. So you have that, and the district court here is like, I'm going to be so careful. I'm not even going to repeat it. I'm not even going to mention it. Versus an entire day where he admitted, juror number 9, admitted's the wrong word, juror number 9 acknowledged that yes, it affected what I say. Secret toxins pumping into the 11 other members of the jury. It's not enough, and my time is up, so no other questions.
Thank you. Thank you, counsel. I think we'll see you again in a minute, but Mr. Pierce, we're happy to hear from you.
Thank you. May it please the court, James Pierce of the United States. The district court correctly concluded that this case involved a permissible application of the permissible domestic application of the wire fraud statute. It did not abuse its discretion when it denied the defendant's mistrial motion, and the sentence that it imposed, including the loss calculation, the restitution, and supervised release conditions, was not erroneous. And I obviously want to focus on the mistrial question, which my friend on the other side did as well. To your questions, Judge Richardson, I think the Remmer presumption doesn't apply here because what Remmer guards against are communications directed at jurors in their capacity as jurors.
All right, so tell me why the first principle's fine, but we have this Wikipedia case where the juror reads Wikipedia about the issue of promotion in a case, and we say Remmer applies there. Right. And so if Remmer applies to Wikipedia, why doesn't it apply to gossip overheard in the supermarket? Right. I mean, first principles, I understand, but how do you distinguish Wikipedia from gossip?
So I think in Lawson is the case there where there's the consideration. I think that is an active effort by the juror as a juror reaching out. Right. So I think that actually looks a little bit like Basham and Blauvelt as well, where the juror is acting in his or her capacity as a juror to try to get information. I mean, in Basham, it's, hey, why aren't you covering this? In Blauvelt, it's more of, yeah, I'm a juror. I appreciate what you're doing. But that person is still acting in a capacity as a juror.
But the challenge is it's not if we're applying the Remmer idea, right, of private communication, contact, or tampering, it's not any of those, right? I mean, we're applying Remmer beyond its own terms to sort of a media type website that was seen, intentionally, but Remmer doesn't talk about intentionality, right? If it's accidental or purposeful, doesn't seem to matter in the Remmer cases, and we apply the Remmer presumption to Wikipedia, so why not apply it to gossip in the same way?
Right. I do think the inadvertence point may come in at the second step if the presumption applies.
I get that, but not at the first step.
Right. I think there is that difference, and I agree. I think Lawson is perhaps broader than how Remmer was initially conceived, but I still think there's a way to distinguish it in that you have a juror acting. The juror in Lawson is not looking up this term unless it's directly related to her. I can't remember if it's a his or a her function as a juror. Right. I think that is distinguishable from somebody who happens to go out to dinner and see, on the TV news, damaging evidence not admitted by the court, and isn't operating out in the public as a juror, hasn't sought out that information as a juror. That was just an overhear, and I think that's not what Remmer it guards against.
Oh, why? I mean, it seems like in Remmer they're concerned about the influence this can have on the jury, and we can't probe the jury after the fact about how did it affect your thinking. And so they create a presumption. And I'm struggling to understand why it matters for that presumption, whether someone was looking at a website as a juror or walking down a street as a juror, or whether, someone intentionally called them and, spilled the beans, or someone accidentally did it in CVS. Why does it matter for the purpose of the presumption?
To be clear, I think it's absolutely appropriate that a district court judge in either of those settings would perform a colloquy and ensure that the juror in question would be able to deliberate. I mean, mapping it onto the facts here, where you have it happen before the actual verdict, and ensure that the juror can deliberate and render an impartial verdict. But I do think what it guards against at its core is efforts, private communications to tamper with the juror. Not to say that there's a place to inquire if a juror overhears, or the information comes from a juror's own efforts to go and ascertain outside information. I think it's appropriate for a judge to inquire. I just don't think that the Remmer presumption should come into play.
I mean, what seems different to me here, and I know there are cases applying it during the trial, but what seems different here is that it's before the verdict is rendered, right? Remmer is we're kind of looking backwards and saying, well, what do we do now that we have this verdict and, we have the rules, we can't impeach it. But when you catch it in the moment, why why do we even need the presumption at all if we can actually find out? The jury here is already deliberating, so maybe the argument is once they've already gone into the room, you're in presumption territory, but it's a little different, isn't it?
I think it is quite different, and I think Judge Richardson raised earlier, I am also not familiar with any case in which a court has had to apply the Remmer presumption when you had something before a verdict had issued. For what it's worth, I think the way the judge, and it was Judge Hazel at this point, described the Remmer presumption is descriptively accurate, that it guards against, I think he used words something, efforts to infiltrate the jury or something more nefarious. But even were this court to, apply the Remmer presumption, and the court below sort of punted on the issue and said, I'll just go straight to whether or not the government has rebutted it, I think the evidence clearly shows the district court didn't abuse its discretion in concluding that the government had rebutted it here. And I think the 2 points on which the district court relied are critically important. One, of course, is that the information that Juror 9 overheard under these, I think, unusual circumstances at best, hearing damaging information, never conveyed that to the other jurors. And we know that not only because that's what Juror 9 said during the colloquy with the district court, but also because the district court went and had an individualized voir dire of each of these other jurors to ensure that they had not heard any outside information. And I know this wasn't part of the discussion here, but my friend on the other side argues, well, that itself was prejudicial. But imagine if it had gone the other way and the district court hadn't done that inquiry. We'd be up here today and the question would be, how do we know, other than Juror 9's own word, that there wasn't some information that actually got to these other jurors? We've never heard from them at all. And so I think under those circumstances, the district court taking the step of ensuring that there wasn't that kind of taint or toxic waste or poison, these various characterizations that my friend on the other side makes, none of that got to the rest of the jurors. And then secondly, of course, because of this unusual posture of having it arise while their deliberations were still going, the district court had the tool of replacing this juror with an alternate, giving the jury the instruction under 24C3 that you wipe your head, you start again, you start to deliberate with this new juror, and you move forward. And of course, we presume that jurors follow that instruction. And there is no Remmer case in which the jury, whether it's one juror or the entire jury, that ends up issuing the verdict has no one on there who's come into exposure or has touched the sort of the damaging information. Now, if there are any other questions on the Remmer point, I'm certainly happy to address them. I have plenty of things to say about the extraterritoriality or the other issues, but I don't want to get into that unless the court has particular questions. So I don't need to, obviously that didn't come up here. So I would just offer to answer questions rather than make affirmative arguments.
I'll ask a question.
Okay.
This is the least important point in the case, probably, about supervised release, because my understanding is when she's released from prison, she'll be going home, right? So supervised release may never happen, but there's been an argument about explaining the conditions of supervised release. A lot of them seem pretty self-evident, but I wanted to ask about the mental health treatment. I know the guidelines say that the judge should issue a requirement of mental health treatment if the judge has reason to think that there's a condition that could benefit from treatment. And I just wondered, I'm legitimately curious because this is a big record, if you are aware of anything in the record that indicated there was a condition that could benefit from treatment, or if the judge was just thinking, anybody who commits a crime like this probably needs a little help.
So I want to answer your question and then make a couple of sort of additional glosses. The PSR, and I think it's around paragraph 111, and I don't have the PSR site, but I think it's around 111 or somewhere between 111 and 115, discusses, as PSRs often do, the mental health of the individual being sentenced. And it talks about how while the defendant is on pretrial detention, she's has stress and she's been recommended for counseling and she likes that counseling and it has been helpful for her. And so I think that would have been before the district court judge, as this is someone who has benefited from counseling and will obviously continue to serve quite a long period of incarceration and would continue to benefit from it while in incarceration. Just to make the points that we do in our brief, of course, the defendant didn't raise this below and didn't sort of challenge the judge into
providing that explanation. And I think that's one of the reasons why it's either waived because it was never raised, or at best reviewable for plain error.
Right. It may not impugn the fairness or integrity of the proceedings.
That's exactly right, Your Honor.
Thank you.
Since you're here, and when I think about the wire fraud convictions, and I think this argument has been waived by your colleague, that the conspiracy is governed by the same analysis as the substantive offense. And your contention is that they've waived the argument that there's a separate analysis if we look at the focus of the conspiracy statute from the other. But do you think that's right? And I understand this is like maybe a little beyond where you probably want to be, but as a matter, as an officer of the court, is it right for us to think about 1349 as having the same focus necessarily as 1343?
So yes, I do think they waived it in page 25, note 4. I think the Ninth Circuit has done the same thing and said when there's substantive and conspiracy law, they ride together. As an officer,
but it also, in the recent decision from Judge Bress, he sort of says they don't make an argument to the contrary. He sort of assumes it away. I'm curious whether that assumption, and maybe it will remain that for this point, but whether you think that assumption is right.
I think it's a lot harder for us because I think that the focus of a conspiracy provision like 1349 is the criminal agreement itself. And so mapping that onto a case like this, I think it would be difficult to argue that the criminal agreement happened in the United States. I think we would still argue that because the criminal agreement encompassed things like targeting victims in the United States, that it was broad enough to nonetheless amount to a permissible domestic application. But I do think absent things like overt acts happening in the United States, which the indictment here would have alleged and would have covered, I think that's perhaps complicated by the fact that I don't believe 1349 actually has an overt act requirement.
Doesn't require them. It's hard to say that the focus of the statute is an element that doesn't exist, right?
I think that's right, and I think that's why it would be a much more challenging case to rely on the conspiracy provision alone. But I agree that that's been waived and is not before the court in this case.
All right. So again, since you're here, and obviously speak up, colleagues, if you have other questions. So sometimes we loosely describe 1343 as having 2 elements, and I think of it as having 3. And I want to make sure that you maybe agree or maybe don't, but help me understand why. So when we look at cases like Taylor, Taylor says it requires 2 things, right? The use of the wire and a scheme, shorthand, right? But in describing the use of the wire there, it doesn't refer to any sort of interstate or foreign nexus, right? So it just gives the use of the wire and the scheme as the 2 elements. And then it goes on in the following paragraph to talk about the interstate nexus as yet a 3rd element. Is that the right way to think about 1343, that you have to use a wire? It has to be in furtherance of a scheme, shorthanding, use or cause to be, I don't mean to shorten all that, but use a wire, a scheme, and then the wire must be in, interstate or foreign commerce, what Taylor talks about as the interstate nexus jurisdictional piece. Is that the right way to think about 1343?
Yes, I think it is. I think I think the point that the court in Taylor is trying to make is also borne out in its analysis, which is the conduct involved is the scheme and the wire itself. And I think the holding in Taylor was, look, the officers there didn't have to know that the wire didn't have to be reasonably foreseeable to them that the wire would travel in interstate commerce, because all that is doing is, I don't want to say all, but what that is doing is providing the basis for federal jurisdiction over the offense. But I think it is absolutely an element that the government must prove as part of its case. There doesn't have to be any sort of knowledge a requirement that attaches to it on behalf of the defendant. The defendants, they don't have to know that the wire goes in interstate commerce.
But they do have to know, as I understand it, that the wire would be used, either they were using the wire or that it would, reasonably foreseeable that it was caused to be used.
That's correct.
Right. And so that's why it really has to be 3 elements, because the first element, the use of the wire, they do have to know that because that's the substantive element. The interstate nexus, as a third element is the jurisdictional hook. They don't need to know that the wire itself crossed state lines.
That's my understanding and my reading, and I think that's consistent with the way Taylor analyzes it. But you're right, the court, I think, there does talk about it as two elements, although I think in many courts use jury instructions that will say three and will say that the wire itself had to travel in interstate or foreign commerce. It's an element. Again, I stand ready to answer other questions. If not, I would ask the court to affirm the judgment below.
Thank you. Thank you, counsel. We're happy to hear from you on reply.
Thank you. And again, considering the amount of issues in the case, much like Mr. Pierce, I mean, if there's things you want to hear, I would rather answer your questions than.
Do you disagree that, just to go to that one point, that when Taylor describes two elements, neither of which include any reference to interstate or foreign commerce or interstate or foreign wires, and then the next paragraph talks about the third element, which is the interstate nexus, and that's the right way to think about 1343?
I would, Your Honor, say actually it is two elements. There are lots of cases saying it's two elements. And I think the wire is necessarily in interstate commerce. So I think.
No, but it doesn't have to be, right? So the issue comes up from time to time, depending on the nature of telephone systems and internet access, that you can use a wire that actually never crosses state lines, right? And so, but the act element is the use of the wire. The interstate nexus is a separate element.
I think they're intertwined. I think they are one element, but I see.
What's the best? I mean, so Taylor treats them as separate, right? So Taylor treats them as not being the same. Do you have a case that says that they are the same?
And I guess, Your Honor, I just read Taylor differently. I think Taylor necessarily says that's our whole argument about Taylor, is that wire is the interstate commerce element. One thing I want to say is we're talking about that one decision this court has to make. I think we agree was this a domestic application, that Congress didn't expect this to apply extraterritorially. So is the focus the wires or is the focus the scheme? Now, I think in Hussein, McClellan, Napout, the First, Second, and Ninth Circuit cases, they all said, obviously, it's the wires. I would just caution this court. I think easy cases can make bad law. I think in all three of those cases, as we point out in our reply brief, there were enough domestic contacts that even if the focus had been the scheme would have been domestic. There were domestic bank accounts, there was physical presence in the United States. And if this court adopts the wire theory, I would say, look at it's the Southern District of New York case, Prevzion Holdings, where a wire sent from South America to Europe, and it just happens to go through New York. If this court adopts the wire theory, then that suddenly becomes a domestic case.
Well, no, it doesn't. I mean, the question of the focus, first we have to decide what's the focus,
Yes.
and then we have to decide if there's sufficient here to make it a domestic case. It's not as though one wire, every future case where one wire happens to pass through the U.S. by happenstance becomes a case where the government can bring a domestic prosecution. Do you agree with that?
I would not, Your Honor, if you say that the point is protecting wires, then I don't see why you would say we don't care about protecting one wire. We don't care about protecting two. We only if the focus
those courts have said it's the use of wires and the furtherance of a scheme to defraud. That's the focus.
Well, there's wires and there's the scheme. It's always wires in a scheme to defraud. So is the focus, as our cases argue, the ones we rely on, district court cases, but we agree with their reasoning, is the focus the fraud, the scheme, or is the focus the wires? The focus should be on the scheme. Now, even then, I get that. I think that gets us 80% of where we need to go. And 21 seconds left. I'll say, there's still an argument that there was some domestic touching of the scheme here, but the vast majority of the contact. I want to say one thing about the sentencing, Your Honor, the Rogers Singletary point. We would just note this sentencing happened before Rogers and Singletary, so we do not think the district court's reference to standard conditions was enough. But again, the district court did not have the benefit of this court's holding that it needed to explicitly announce or incorporate a set of conditions. So we do think.
Is that, so I'm just, I'm misunderstanding those cases, but I understand those as being two different points, right? One, that you can incorporate standard conditions that Rogers says that's okay.
Yes.
Rogers separately says you can explicitly incorporate non-standard conditions by reference to, you know, a PSR or something. But those are two different ideas. Well, is that not the right way to read Rogers?
No, those are two different ideas. And the point, Your Honor, is that when the district court here said standard and statutory conditions or statutory and standard conditions, that we don't know what standard conditions. If the district,
but Rogers tells us that that's okay, right?
I don't think so, Your Honor. I think Rogers says if you say the standard conditions in the guideline, the standard conditions at the time, the District of Maryland did not have a standing order. But if you reference a standing order, if you reference the list in 3583D, there's a list the judicial conference has put out. So if you say standard conditions, as he did here, as the judge did here, that's not enough. If he had said the standard conditions of the guidelines, that would have been enough.
So the standard conditions of the guidelines were the standard conditions that were included in the PSR. And they're also the standard conditions that are the, you know, standing order that now exists in the District of Maryland, didn't exist at the time. These are all the same. And in Singletary, they seem to assume that reference to standard conditions referred to those in the guidelines. So was anyone actually confused? And if they were, why didn't they object?
I do not know if they were confused, Your Honor, but I will say, and I do not know why they did not object. I only rest on the point that when you say something like standard and statutory conditions, when there's lots of lists of standard conditions floating around,
But are there?
That's not enough. Yep, there's lists in the statutes. There's 3583D.
But the guidelines has a section that says standard conditions, and they're exactly the same as the ones that were in the PSR, and they're the ones that are applied here. What's the confusion?
The court has to. So the confusion, Your Honor, is there has to be an express incorporation of a specific list. And the question isn't how similar are all these different lists floating in the air. And the question isn't even one of confusion. The question is, the point is you have the right to be sentenced in open court. And part of that sentence is the conditions. And part of being sentenced in open court is having an express specific list, which I'm sure the District of Maryland is in fact doing now. In fact, they have a standing order now, Your Honor, in response to this court's cases. So I just, I wanted to say, obviously the district court pre-Rogers, did not understand its obligations in a way I'm sure it would today. I see I'm significantly over time. Obviously, any questions? Happy.
Well, we certainly appreciate your argument from both of you. We certainly wish we could come down and greet you, but I'm sure you understand our hesitation to do so at this point. But thank you for being here and presenting excellent argument in a complex case. So thank you very much.
Thank you.
We'll stand in recess if the court will do so.
Tomorrow morning, God save the United States. This honorable court.